Thomas Daly, representing the co-applicants, along with Robert Honey, also representing co-applicants, and Mr. Hill Welford, who will be on Zoom, also representing the co-applicant Tetra.
All right, and you don't need to stand. Formality isn't necessary in this proceeding. Let me ask you again, Mr. Daly, you were representing who? I'm sorry, I should have been taking notes.
The collective co-applicants.
Collective. Okay, so you,
I actually represent only Southwest, SWA 15,
okay, so Southwest in what?
SWA,
right?
Lithium,
Yep. That's the only one you're representing, Mr. Honey? Okay. Mr. Perkins, hiding a little bit behind the lectern, but I can still see you, sir.
I'm Alan Perkins, and I represent the South Arkansas Minerals Association.
Mr. Perkins, I know that there have been some other objections. I know Mr. Rankin filed a letter in response to two or 3 days after the SAMA letter was filed. You're just representing SAMA's interest, is that right?
That's correct, and the motions that were filed were in response to SAMA's objection. So yes.
Well, there was some,
but
yeah, there was some reference to other objections incorporated, but I understand. Yeah. Okay, just to be clear. Mr. Pinkleton, I know who you represent, but would you please identify yourself for the record, please?
Absolutely. I'm Daniel Pilkington. I'm attorney here with the Department of Energy and Environment. I'm here representing the commission staff of the Arkansas Oil and Gas Commission.
And you have to your left.
Keisha Morrison, Chief Counsel, Department of Energy and Environment.
Thank you, ma'am. Mr. Hickey?
Yes, sir. My name is Patrick Hickey. I'm with Joseph Hickey PA, and we represent several objectors, including Simmons Bank on behalf of various trusts that they're serving as trustee of. The Edie family, which is several trusts and an individual, a gentleman named Mr. Wayne Weathersby, and a family limited partnership called the M. Johnson Family Limited Partnership.
And if it's okay with you, Mr. Hickey, I'm gonna, as we go through this, I'm going to collectively refer to those folks as the Hickey objectors, if that's okay. I think that's the easiest way for expediency. I don't want to run through a laundry list of your objectives if I could. I know that this matter is being YouTubed, is that right, and Zoomed. Again, for those that are listening via the internet, I'm not here to hear your objections. I'm not here to hear your testimony. That'll be for another time, potentially November 4th and 5th. And I don't know whether or not IT has silenced those folks on YouTube and the Zoom. Is that correct?
Let me test that out. Are you able to hear me? This is Hill Welford on the picture.
I am, sir, and I can see you. I mean, I think I don't know whether or not logistically, and again, that's why I don't want to necessarily silence everybody. But I also don't want it to be gravitate into a circus as well. So I'm going to rely heavily on what Mr. Daly and Mr. Honey say. If you think they're missing something one way or another, I'm not inclined to cut you off or whatever. But since you are an attorney and since you are representing parties, I will certainly listen to your argument in terms of filling in any gaps that you think might have occurred. But that would be the only person on Zoom that I will listen to in terms of argument.
Judge Moulton,
Ms. Clegg.
this is Carolyn. This is Carolyn Clegg. I represent Saltworks.
Okay, I am so sorry, Ms. Clegg.
That is fine. Thank you.
I certainly will hear from you as well, ma'am. My
Thank you
apologies.
so much.
All right, Mr. Pinkleton.
Just one thing to clarify on the record, can we explicitly refer to who the applicants are? I believe it's 5 different operators, but I just want to make sure because there's going to be references to the applicants that we specify who they are.
So according to my notes, we've got 3 motions filed by Albemarle, Saltworks, SWA Lithium, Lanix, and Tetra. Those are the motions. Is that correct, Mr. Daly? All right. This is how I want this proceeding to move forward. I'm always cognizant of trying to get as clear a record. So rather than have the lawyers get up and just argue everything all at once, that tends to circle down into chaos over time. I'm going to ask you, I'm going to address the specific motion, and then we're going to go through the points that you raised, Mr. Daly and Mr. Honey, in that motion. So the first motion I've got is your motion for declaratory judgment, seeking a decision that finds that the first point is, we got three of them in this motion. The first one is that the Arkansas Oil and Gas Commission is empowered by statute to determine royalty for additional extracted substances, that the Arkansas Brine Conservation Act and the Arkansas Oil and Gas Commission's administrative hearing process is constitutional, and that the third one is the brine leases and integration orders covering the brine interests owned by the Hickey objectors include all chemical substances extracted from brine, including lithium. Have I properly covered those 3 points, Mr. Daly?
Is the response to the Hickey.
That is correct, sir. And that's the one we're going to take up first. All right. So I will hear from, I guess, either Mr. Daly, Mr. Honey, and we can just do it if you be so kind, Mr. Daly, like one point at a time. We'll hear the first argument in terms of, or I'll hear the first argument in terms of that the commission is empowered by statute to determine royalty for additional extracted substances. And we'll hear from Mr. Hickey, and then maybe Mr. Perkins and Mr. Pinkleton on that point, and then we'll just move through it methodically, point by point. I think that just makes a clear record. Please, yeah, please, if you could. I think it's beneficial for me, as well as the court reporter. We're kind of spread out here at this point. So if you would be so kind as to make your argument at the lectern, I would appreciate it.
The Hickey objectors raise an interesting point. I don't think a valid point, but an interesting point, that nowhere in the statute does it specifically say that the Oil and Gas Commission will determine the additional compensation which must be paid upon profitable extraction of some substance other than, in this case, bromine. But it certainly infers that. First of all, the Oil and Gas Commission has to determine, has the power to determine whether or not that compensation is due at all. Vis-a-vis, it has to have been profitably extracted. Otherwise, they don't owe anything. You can profitably extract, or you can unprofitably extract. If you unprofitably extract, there's no rule against it. You just don't have to pay any royalty. The statute also permits any royalty owner who would be a beneficiary of the additional compensation to apply to the Oil and Gas Commission to demand an accounting. This is an Oil and Gas Commission which is also given under the statute very broad authority to take all those actions and issue all those orders which are enable the implementation of the act. I don't think it has to say in so many words, oh, and by the way, they will set the amount of the compensation. After all, they're determining whether or not it should be paid, and they're supervising this accounting. It seems pretty clear to me.
Let me stop you right there, Mr. Daly. I think you're getting a little bit far afield in terms of, as I understand your motion, what you're saying is that the statute, the enabling legislation, has empowered the Oil and Gas Commission to pay a royalty for any additional substances that may be extracted from brine that were not extracted prior to 1979. Yeah. That's it, right?
Well, not to pay a royalty, obviously, but to determine the
proper accounting for the royalty.
So, I mean, it appears to me by the statute that that's exactly what the Arkansas General Assembly has contemplated when it enacted the Brine Conservation Act of 1979. Am I missing something?
No, I 100% agree with you.
Okay. I think that might be it. Mr. Hickey, please.
Would like to start by submitting a supplemental citation to the brief that I submitted.
Sure.
May I approach? Judge, may I approach?
Sure.
When you read the Brine Conservation Act, it does not explicitly state that the commission shall determine the fair and equitable royalty.
Let me stop you right there then, Mr. Hickey. What does this mean? It says Arkansas Code annotated in section 1576, 315C1 states, in addition to any amounts due and owing by the producer or producers of any unit to the owners therein, the producer or producers shall account separately and on a fair and equitable basis to each owner in the unit for all substances which are found by the commission to be properly extracted from brine by a producer and which were not extracted by a producer on January 1st, 1979. What does that mean to you?
What that means to me is that the producer shall account separately and on a fair and equitable basis to each owner in the unit. It does not state that the commission is empowered to set that royalty. There's no reference there. If you'll step down to C2, it explicitly does state that the commission shall determine whether or not it can be profitably extracted.
Well, your argument is that they don't have the statutory authority to do any of that, as I understood your objection.
No, sir, that is not correct.
Okay. What are you trying to say?
What I am saying, is that the way that the statute is written, the commission is empowered to determine whether or not it can be profitably extracted. It is not empowered, it does not have authority or jurisdiction to set the royalty amount.
Okay. So they can determine whether or not it can be properly extracted, but that's the limit of their authority.
Yes, sir, that is correct.
Okay, that's all right. Okay.
And in reliance upon that, I've cited there Loper et al. Versus Raimondo et al. And in holding the court should not defer to agency interpretation of applicable statutes because the statute is ambiguous, the Supreme Court of the United States reasoned in part when substantive hurdles remain, Congress should expressly delegate that authority. Determining a fair and equitable additional consideration to be paid to the brine and lithium mineral owners is what was referenced as a deep economic and political significant issue. Here in this case, if the General Assembly wanted the Oil and Gas Commission to set that royalty, it should have expressly done so.
Mr. Hickey, are you familiar with the cases handed down by our state Supreme Court, Missouri Pacific Railroad versus Strohopper?
Yes, sir, I am.
What do you think that means?
I don't really understand how, I don't understand your question and how it's applicable here.
How about the Ahan versus Reinhardt and Dunham and Company case? That was handed down in 1966. Are you familiar with that case?
No, sir, I'm not.
Okay. How about DM Ritchie Inc. versus McGowan Working Partners, a 2002 case? Are you familiar with that one?
Yes, sir, I reviewed that.
What do you think that one means?
I'm not sure how it's applicable here.
Okay,
Once again, the Supreme Court of the United States decided this year that the court shouldn't defer to agency interpretation, and they relied in part on the fact that when a statute is ambiguous, it should be expressly delegated for an agency authority to take an action on something, especially when it is an issue of deep economic and political significance, like setting a royalty rate. And so, as I stated in my brief, I believe that the co-applicants need to go to the commission, seek a determination of profitability, and then go back to the landowners and negotiate fair and equitable compensation. If that does not work, I believe the state legislature needs to step in, clarify this, and they need to explicitly state that they need to go to the commission first, set a determination for profitable extraction, and then using those numbers, they need to determine what the fair and equitable additional consideration would be.
all right, thank you, Mr. Hickey. Mr. Perkins, want to weigh in on this one?
I do, and I won't agree with Mr. Daly very many times today, so I thought I'd take this opportunity. I think we can't ignore the big picture. The commission clearly under 1576-306 is given very broad authority. The Oil and Gas Commission shall have jurisdiction of and authority over all persons and property necessary to administer and enforce effectively the provisions of this subchapter. And the additional substances language that we've all read and that you read a moment ago is certainly one of the provisions of this subchapter. The Oil and Gas Commission has authority to and jurisdiction over all persons and property necessary to do that. And there really is no other practical way for this to happen other than for the commission to make that decision. And that's all I have, unless you have questions.
I'm gonna shift your focus to the 315C1, and I agree with you in terms of the 706-306 language. It certainly says the Oil and Gas Commission has jurisdiction of and authority over all persons and property necessary to administer and enforce effectively the provisions of this subchapter. And 306A also says the commission is authorized to make, after hearing and notice, such reasonable rules and orders as may be necessary in the proper administration and enforcement of this act or the act, which of course is the Bryan Act. What does it mean in 315C1 in your mind that in addition to any amounts due and owing by the producer or producers of any unit to the owners therein, the producer or producers shall account separately and on a fair and equitable basis? What does account mean?
I think that means that they have to pay them the royalty individually based on their proportionate share in a unit. It refers to units several times in this provision at the rate that is fair and equitable.
Right. All right, thank you, Ms. Perkins.
Thank you.
Mr. Pilkington?
Commission staff's position on this matter is that the commission has the authority as granted by the Arkansas General Assembly to address the additional fair and equitable accounting and basis to be remitted to the royalty owners in the unit. And I believe that Mr. Daly in his brief had cited several authorities. The commission staff agrees that those authorities are valid to grant the commission the authority to hear those matters. The only thing I would add to that would be, I believe it's in 15-76-3014, where there's the declaration of public policy. I hate to hammer one word in particular that is it there, but it does specifically say that the commission has the authority to administer and enforce all of the provisions of the subchapter. I take that to mean that every provision that is in that entire subchapter, if there's a question as to how it needs to be enforced or who's to preside over that, it's to be the commission. So I would emphasize that the General Assembly has been very emphatic in saying that the commission administers all of it, including 315C, 1 and 2.
The previous iterations never included that language about accounting for additional substances. Is that correct?
I believe that's correct. I don't know the exact legislative history, but we've always looked at it from the commission staff perspective as when you're looking at brine production, there's the possibility of 2 or more payments depending on what exactly you're producing and you're extracting. You have the 315A part, which deals with the production of brine, where there is a statutory value that has to be paid for the volume that's produced. The way it's set out, there's a statutory floor. If you're extracting other substances, depending on when they first were properly extracted, there is an additional amount that has to be paid for the profitable extraction of those substances. We've obviously, through some of the briefing, there's references to other hearings where there's been profitable extraction of other substances from the brine in the past.
Right.
Here we're dealing with lithium. So if there is profitable extraction of lithium, there will be a brine payment that has to be made, and I believe is currently being made by these applicants in units where they're producing the brine. Then there's the additional accounting or at least method to show how you are paying for the additional profitable extraction of those other substances.
And there is precedent already from the Oil and Gas Commission about this double payment of a royalty.
That's correct, Your Honor. That I don't know exactly what the substances are. I always get mixed up, but we always just call them the salts. I believe it was a 2007 Docket matter. I believe that's referenced in Mr. Daly's brief as well. There is a precedent where this commission, presumptively through the authority that was briefed in Mr. Daly's documents, where the commission has exerted authority without, I'm not aware of any objection from others, when the commission did preside over this exact same thing, figuring out the basis and the method under 315C in a previous hearing.
What about to Mr. Hickey's point that the word royalty isn't expressly used or applied in this additional substance section of the Act, specifically 76.315C1? What's your response to that?
We have noticed that over the years. We don't like calling it a royalty because the statute doesn't refer to it. We like to say that what the commission has to determine is the basis or the method for how you pay. It's hypothetically possible where you're doing some type of in-kind even, or some other type of value that's presented without a royalty as far as that goes, but you have to account and show how you're providing through some method that's approved through the commission, how you're going to provide consideration for that additional substance being properly extracted.
So to your point, does the Brine Act ever use the term royalty?
I'm not sure. I did look the other day and I could not find where the word mineral was ever used in that subchapter. I'm not sure. I think royalty owners may be used there. So we have used the term royalty owners. And I think that is somewhat designated by who is entitled to the consideration within some type of field or unit where brine is being produced and the profitable extraction of that additional substance is occurring. But I don't think it does say royalty. That may have to be a homework assignment for me to look at that. But we do believe that the additional consideration, I'll call it that, has to be provided through the operator.
And perhaps royalty has in and of itself a specific legal connotation, and perhaps the General Assembly this time, in their wisdom, didn't want to use the term royalty to give the commission the flexibility to account for those additional substances for a payment to those owners of that substance.
If I may add something to that as well, we do have a royalty complaint statute that is, I believe, in Chapter 74, one of our other oil and gas statutes. And when somebody who believes they're entitled to a royalty, they can submit a royalty complaint to us. We investigate and we determine if a royalty is owed. We have never clarified on that issue whether or not a brine person entitled to some type of compensation would be subject to that. I don't think that's entirely clear, partly because that statute does not address brine in its terminology, but also partly because royalty is not explicitly used in the Brine Act, if that helps at all.
Thank you, Mr. Pimpleton. Appreciate it. Mr. Daly? Yes, sir.
Yes. Just a couple of points of clarification here.
Oh, boy, you're pulling the laptop up. I don't know if that's a good sign or a bad sign, Mr. Daly.
I think it will be helpful in this instance. You made the comment earlier that, or the question you asked was a previous iteration of the act include this language? Mr. Hickey has said in his objection that it did not. That is incorrect. The 1979 Act has the identical language which is in the present Act. I will hand you a copy, if I may approach, of Act 937 of 1979 and call your attention to page 2088, item C, which is in fact the identical language which is in the current statute. Mr. Hickey has designed a whole scenario about how the legislature went back to fix a mistake. There was no such go back. There was no such mistake. That is someone's imaginary scenario.
Yes.
The word royalty does appear frequently in the statute. That's why I brought my laptop up here, because you can search.
Right.
And I can't. There are 29 matches in the statute for the word royalty. I can tell you that in the early days, and even when you're able to read the articles that we filed as exhibits to the application and the history of all of this, this started out and remains as to bromine something which I would more characterize as a rental as opposed to a royalty, because it's not based on production. It is an annual sum paid quarterly and escalated with a government index. But nevertheless, it's clear, even with the reading of the original act and the statute, that it was a form of royalty, although kind of a different one.
And Mr. Daly, I mean, are we getting, of course, with legislation, you're always getting hung up on semantics, but at the end of the day, whether it's accounting or royalty, doesn't matter.
You can call it what you want to.
Okay.
Absolutely. And the only other thing is the correct docket number of the SALT hearing, which involved 3 salts that began extraction in 2007 with a commission order. It was order reference number 173, 2007-04.
All right. Thank you, sir. Mr. Parkins?
I don't want to belabor this point, Judge, but 1576-315, I mean, there was a question about, does the act even refer to royalty? It does a number of times in this very section. So it begins with talking about establishing an amount, and then it talks about the owner's ability to seek an accounting in 1576-315 A1, or excuse me, A2 says, in any action by any owner against the operator of the unit for an appropriate accounting for royalty, the burden of proof that the value as determined hereunder constitutes a fair and reasonable market value of brine produced from the unit shall be upon the operator of the unit. And then in 3, it says, however, no valuation of brine or any other alternative method of computing royalty or in lieu of royalty, which we refer to the per acre amount, the payment for bromine as in lieu of royalty because of this particular reference, shall ever result in compensation which is less than $32, etc. And then over in 315C, which is the additional substances subsection, we've been reading 1 and 2, but subsection 3 says 3A, except as provided in subdivision C3B of this section, the accounting by the producer shall be on a quarterly basis and shall be accompanied by payments due to royalty owners. The producer's responsibility for making royalty payments shall commence upon the occurrence of either of the two following events, and then it goes on to describe those. So whether we call it royalty or something else, it's a payment to the owners of the minerals who are entitled to some share out of their minerals that are produced and sold. But the statute clearly refers to royalty in a number of places.
I thank Mr. Perkins. Mr. Hickey, I'll give you the last shot here on this point.
Thank you, Judge. So 306 B and C were both referenced, and I addressed in the brief there that in neither of those places does it explicitly state that the commission will determine the fair and equitable consideration. It's not enumerated.
Well, this was kind of, Mr. Perkins kind of stole my thunder because I was going to ask you about 3A. Again, I'll just reiterate what Mr. Perkins said, except as provided in subdivision C3B of this section, the accounting by the producer shall be on a quarterly basis and shall be accompanied by payments due to royalty owners. The producer's responsibility for making royalty payments shall commence upon the occurrence of either of the two following events: the day of the filing a petition for an accounting and the time of the profitable extraction of other substances. So it seems to me that the General Assembly is using the phrase accounting and royalty interchangeably. What's your response to that?
Yeah, so I believe there's been a miscommunication. I never questioned whether or not royalty was at issue here. What I'm trying to communicate here is that the Act does not explicitly authorize the commission to set this fair and equitable rate, okay? And with regard to 315 being added, when I researched in Westlaw, it showed that it was added in 1995. And if that is not the case, it was not my intention to deceive or mislead the commission or the court. But according to the red line,
2024, Mr. Hickey.
I'm sorry.
It is 2024, even if it was added in 1995.
Yes.
It's still in force and effect, right?
Yes, I believe that it is. But I mean, so we've kind of stepped into another issue, which is the mistake of law issue here. And so he was trying, counsel over here was trying to address that. And you are correct. Yes, it is in effect right now. And the way that the statute is written, whether or not it was written in 79 or in 95, I do not believe it expressly authorizes the commission to set this rate. It does authorize the commission to determine whether or not the substance can be profitably extracted. And following that logic, I believe that the co-applicant should go and produce the financial numbers and show that they can profitably extract it, and then the commission.
Get into an issue that we're going to address further on down the line.
Okay,
that's fine.
Mm-hmm.
All right, thank you, Mr. Hickey.
Yes, sir, thank you.
All right, next issue that I have is in your motion, Mr. Daly, in terms of your declaratory request, is the issue of the Arkansas Brine Conservation Act and the Arkansas Oil and Gas Commission's administrative hearing process is constitutional.
My argument on that issue is very short. If you will read Goanus versus Arkansas Oil and Gas Commission, Excellent opinion written by the late Chief Justice Hannah. You will, I have to believe that this has already been decided. And Mr. Hickey can put all kinds of spin on it and say, well, it's not the statute, it's the process. I'm not sure that I'm smart enough to understand that distinction. It has been held to be constitutional and as a legitimate exercise of the police power of the state. Mindful of the chaos that would result if the Oil and Gas Commission did not have the authority to unitize and control areas, given the limitations on the rule of capture and the potential for trespass litigation. I don't think it's an issue, but it's raised and if Mr. Hickey doesn't want to notify the Attorney General, fine, he can do that at his own risk. I'm suggesting he should.
Before you step down, Mr. Daly, just a couple of questions. So you've essentially raised one argument, which is that any act of the General Assembly is presumed to be constitutional, at least at the administrative level. And I believe you cited the Lincoln versus Arkansas Service Commission case as precedent for that fact. And then you had your two other alternative arguments in terms of Mr. Hickey's constitutional or unconstitutional argument is undeveloped or was undeveloped, and the service on the Attorney General. So theoretically speaking, if I find that, certainly that Mr. Hickey can raise it, but if the Oil and Gas Commission lacks jurisdiction to even make a ruling on a constitutional argument, do I have to reach the other two issues? At that point, aren't they moot in an advisory opinion? If I find that we don't have the jurisdiction, or the commission doesn't have jurisdiction in the first place, I don't have to get to the other two issues, do I?
I would agree with that.
Okay.
I can't imagine that would be your finding, but I would certainly agree
Right.
that the logic of what you said.
Right. Okay. Thank you, sir.
Thank you.
Mr. Hickey?
So I said in my brief that the objectors are not challenging the constitutionality of the act. The way that the co-applicants try to apply the act takes the objector's property without due process, and it interferes with the right to contract.
I understood what your argument was.
Okay. I don't have anything further to add.
Okay. Thank you, sir.
Thank you.
Mr. Parkins?
I agree, it's constitutional. I don't have anything to add to Mr. Daly's comments.
Mr. Pilkington, anything you want to add?
Commission staff's position is that procedurally, everything that has been done by the applicants here are constitutional. We have no concerns.
Thanks, sir. Ms. Morrison, I'm leapfrogging over you every single time. If there's something that you want to say or weigh in, raise your hand and let me know. It's not my intention to skip over you.
I told her a second ago, the next time you ask me something's in a statute, I'm going to ask her before I make a response.
All right, anything anyone else would like to add on that particular point? If not, let's see here, Mr. Daly, your third point. Brine leases and integration orders covering the brine interest owned by the Hickey objectors include all chemical substances extracted from brine, including lithium. I'd like to make an argument.
This will be even shorter than the last one. I read the leases and they lease the lessor's brine and constituent parts thereof. the words mean what the words say.
Thank you, Mr. Daly. Mr. Hickey?
As outlined in the brief, it's not an issue as to whether or not the constituent parts are also leased. It's an issue of mistake of material fact. The consideration would have been appropriate if the parties had known that valuable lithium was covered by this. And it was only commensurate with what was known to be profitably extracted at the time, bromine.
Why isn't that just a flat out contract dispute, Mr. Hickey? Why is that even bootstrapped to the statute? I mean, they've signed leases. If you're saying that there was a mistaken of fact when they signed the lease, isn't that between the landowners and the producers?
Well, I suppose it would be, but if the leases are essentially not covering this because it did not provide appropriate consideration and it was not considered at the time, then the commission needs to take that into account when deciding whether or not it's going to set any type of royalty here.
But doesn't there have to be a finding that there was a mistaken issue of fact in the lease? Don't you have to have some sort of a ruling on that before we get to the commission? Isn't that a condition precedent?
I'm not sure about that.
Okay. All right. Anything else, Mr. Hickey?
No, sir. Do you have any other questions?
No, sir. Thank you. Mr. Perkins?
Again, I don't want to belabor it, and I don't have any reason to think that you're not going to agree with this already, but I want to make sure the record is clear. So the Brine Act also defines brine. So in 1576-302, 2A, it says brine means salt water, whether contained in or removed from an aquifer, and all other chemical substances produced with or extracted from such salt water except for commercial production of oil and gas. And then you also have the very practical reality that brine is salt water, and you can't produce an element out of the salt water without producing it all. It's just not physically possible.
Something, but I'll rethink it. Thank you, Mr. Perkins. Mr. Pinkleton?
Any questions about anything in the statutes or anything? Let me know ahead of time so I can bring the statute up here.
Well, maybe I'll ask you, I don't know how many of these leases that you've seen. I was going to ask Mr. Daly this, but do the leases that you have seen, let me ask you, have you seen some of these leases?
I have seen some. I believe they were exhibits to Mr. Perkins' objection.
I saw those as well.
Yes, sir.
Beyond the ones that were attached to Mr. Perkins' objections, have you seen any other leases?
I don't believe so.
Okay. Well, then I'm going to save my question for Mr. Daly.
Okay.
Thank you, Mr. Pinkleton.
Sure. Okay. Commission staff's position is that the statutes lay out explicitly what has to be done from a procedural standpoint, and the applicants have followed that procedure.
Thank you, sir. Mr. Daly?
Sure, I've seen a lot of leases.
I know you have, sir. Way more than I ever want to see, put it that way. So the question I have is, I'm going to go on the assumption that the leases, to a certain extent, track the verbiage in the act. Is that fair?
I cannot promise you that they all do. I can assure you that all I've seen do, and they do something else, which is when you get into the area of additional substances, and when you get into the area of brine royalty or in lieu royalty, whatever you want to call it, they defer. They specifically refer to section 1576-315. The words 1576-315 appear in a clause of each of the leases that I am familiar with. And so they effectively, by contract, adopt the statutory process.
What about Mr. Hickey's contention that there was a material mistake of fact when
Well, okay.
the landowner signed these leases?
If I must, for one thing, there's no such thing as a mass mistake of fact. That is a concept which is individual, and there is a very, very high barrier to proving it. That is requires a very strong burden of proof. Secondly, as you observed, this is a matter of try and title. The Oil and Gas Commission doesn't try title. Never has, never will. If there are royalty owners who claim that their ancestors, in most of these cases, were mistaken when they signed these leases, which clearly say Bryan and its constituent parts, I suppose that that is a way that they can go spend their money in circuit court. But it is totally beyond the jurisdiction of the Oil and Gas Commission to be trying title to leases, be they individually or as a group.
All right, thank you, Mr. Daly. Mr. Hickey, anything else you'd like to add, sir?
Yes.
Thank you very much. All right, I believe that addresses your motion for declaratory relief as it relates to the Hickey objectors letters. Is that right, Mr. Neal? I think I covered everything. All right, let's gravitate into your motion for declaratory order as it relates to the SAMA objections. And I'm going to lump everybody. I know in your motion, I believe you referenced or included some of the other objectors, at least as it overlaps with what SAMA put into their objection. But I'm just going to refer to everybody as the SAMA objectors, if that's okay with council. So the first item I've got, or the first request that you have, Mr. Daly, is that the co-applicant's application does not violate the Arkansas Administrative Procedures Act. That's number one. I'm taking them a little bit out of order in terms of how you set them up in your motion, Mr. Daly. That the second one is the Bryan Act does not require that a royalty rate on additional substances be determined on a unit by unit basis. The third one is that Albemarle has standing to participate in this docket and in the application. And the last one is the Bryan Act does not require the Arkansas Oil and Gas Commission to wait until an additional substance is extracted before determining a fair and equitable royalty on the additional substance. And I'm saving that one for last because I think it's linked to your motion to quash to a certain extent. So I think on that last point, we might be arguing all of it at the same time, which is why I've set it up to be the last issue. So let me hear argument first on the co-applicant's application does not violate the Arkansas Administrative Procedures Act, if I could. Mr. Daly.
Mr. Perkins accurately quotes the Act, and that is the Administrative Procedures Act, and the law on the question of what is a rule and what is an application. And a rule is a determination of generally with general applicability. For good reason, the co-applicants have a lot of acreage under lease. And that acreage is concentrated in 4 specific Arkansas counties, Union, Columbia, Lafayette, and Miller. And for good reason, we believe they have applied jointly because they see strong public interest in the administration of a uniform royalty scheme, at least insofar as their properties are concerned. However, the application is limited to the interests of the co-applicants in those specific counties. It, for example, does not include the lessee of the leases that Mr. Perkins has filed as proof of something else, or attempting to prove something else. That entity is not affiliated in any way with the co-applicants, and if and when it becomes a serious player and wants to do something other than just go buy leases, it will have to deal with this process on its own. That's the definition of an application as opposed to a rule. And you know, the fact that the application includes a lot of acreage and includes multiple applicants is certainly not prohibited by any rule of the commission that I'm aware of.
What about Mr. Perkins' argument, though, that an order issued in this docket is effectively or tantamount to a statement of, let me see if I get the right verbiage here, a statement of general applicability in future effect?
I don't know where it comes from. I mean, I will candidly agree that when the Oil and Gas Commission makes a decision, that decision should be somewhat of a precedent in future matters if in fact the circumstances justify. I mean, we all rely on stare decisis, but there's nothing to bind the commission as far as, for example, this other lessee is concerned. And there are more of them out there, by the way, you know, beating the bushes trying to get into the deal. There's nothing whatsoever in this application or the statute or anything else that would preclude them from asking for something different or for the commission applying something different. I mean, he's talking about a predicted possible result or maybe even a predicted probable result that the commission would actually follow its own precedents. But that would be the case whether this was 5 applicants with 500,000 acres or a single applicant with 5,000 acres. It would be a precedent.
So you're saying that future effect is more precedential as opposed to a blanket. How about if I put it this way? And I know it's remote, but let's just say for the sake of argument, a source of lithium was discovered in Crittenden County. Would an order from the Oil and Gas Commission in this docket bind the decision in that county?
Absolutely not. If it were one of these co-applicants, then one of 2 elements would have been satisfied, but the Crittenden County would preclude the other one from being satisfied. It would have to be in Union, Columbia, Lafayette, or Miller.
Thank you, sir.
Yes.
Mr. Parkins?
Thank you, Judge. I don't think Mr. Daly said anything incorrect factually, and I agree with him that there are other lease hounds out there taking lithium leases, but the fact of the matter is they're boasting of 500,000 acres, and these applicants control the brine field in those counties. And so even their application seeks approval of a compensation methodology that would apply to all future units, integrated, unintegrated, anything that those parties are tied to. And this really, in a lot of ways, interrelates with the other argument that we're not going to get to yet, that it should be done on a unit by unit basis.
Right.
It's clearly prospective in nature, and they want it to have a general effect. In fact, the Big Five finds it hard to even describe what they're asking for without using the word rule in their response. On page 2,
I saw it, Mr. Perkins. I saw it, yeah.
The co-applicants who are competitors of one another have a common interest in requesting the commission to set rules which apply to them uniformly, as opposed to potentially giving one or more a competitive advantage over the others. That's true. They are seeking to wipe out the competition to make it uniform across the entire set of producing counties, and that is tantamount to a rule, not an order. Thank you.
I mean, I understand your argument, Mr. Perkins, is it, it's that old, looks like a duck, quacks like a duck, waddles like a duck, it's a duck, right? But the reality is, if it really was a rule, they're certainly not following the traditional rulemaking process, which in this case, they would have already set a royalty payment, right? Made a decision on a royalty payment, sent it out for public comment, and then based on that public comment, would have made a decision to either finalize that decision or modify it or change it. That's not the process that we're using. Right. We're going to have a quasi-judicial proceeding where witnesses are going to be sworn in, testimony is going to be elicited. I know you're going to cross-examine people because that's one of the things you do best. And at the end of all the evidence, and exhibits are going to be entered in both pro and con for whatever this payment should be. And at the end of that it's an evidentiary hearing. At the end, they're going to enter an order. Now, I get the idea that it has precedential value, as what Mr. Daly just mentioned, but at least as I look at it, from the process that's going to be employed, it's a evidentiary judicial process, which all the case law says isn't rulemaking in order. And so that's a hurdle I'm trying to get over. I understand your argument. I do. I get it. But I also think it dovetails into your unit by unit issue, which we will take up here in a little bit. Anything else you want to add?
No.
Thank you, Mr. Perkins. Mr. Hickey, I'm going to pass you over on this one because this doesn't seem to be like you have as they would say, a dog in this particular fight. But I don't mean to necessarily cut you off, but I think this objection doesn't apply to your letters. At least you didn't raise this. So.
In my briefs and in the objections that.
Oh, I think you incorporated it by reference. Yeah. I apologize. You're right. You incorporated some as objections into yours. So I will ask you anything that you want to add. I apologize. Mr. Pinkleton?
Yes, Your Honor. Reading through this was kind of like strolling down memory lane from the administrative law classes I had in law school. I will say the definition of rulemaking does deal with general applicability. So from the commission staff standpoint, when we received the application, we did analyze this from the hypothetical of who all is regulated. And this is me going back to the term all again on a different matter. In kind of looking through the few cases that we had on this matter, I think there was even reference to a corpus juris secundum article on this as well. What you're looking at is who is regulated, who are the classes, who are the all in this situation. And that's what we looked at. If the commission granted the application as written verbatim, the commission believes that this would be the adjudication of an order because of the hypothetical that was kind of referenced earlier, where if, let's say, John Smith Bryan Production Company decides that they want to set up some type of brine production and want to come on this exact same issue, they're not affiliated in any way with the operators or the mineral interest owners who have been notified of this proceeding. This also doesn't deal with the exact same acreage where the production is occurring. If they came before the commission and said, Commission, we want you to go ahead and determine if we have a fair and equitable basis for paying lithium, and we believe we can properly extract that lithium at this point. In that scenario, I believe you may have already referenced what I'm about to talk about, which is there precedence here? And in that situation, what we've done on similar circumstances, where somebody who has something that is almost factually identical, we have communicated to the commission that this is how the commission has addressed that situation in the past, but it is not of precedential value. So if John Smith Production Company comes forward, we would advise the commission as to what they have done, but we would tell them they are in no way bound by that other decision because it didn't incorporate the all in this circumstance. So just looking specifically at what has been requested in the application, we believe this would be, if the commission grants that application, adjudication of an order.
And I'll ask you the same thing that I asked Mr. Haley, which was, what about Mr. Perkins' contention that, and again, it may be segueing into the unit by unit argument, but that this is a statement of general applicability and future effect if that order is entered, as the application is submitted currently.
It is a statement. It is generally applicable, but it is not generally applicable enough, is our problem. We're not regulating the field in this circumstance. It is potential. It's possible that the applicants end up leasing and doing units over the entirety of the 75 counties in the state to determine what the method is. At that point, I think you're there. It's the whole all aspect of this. It's the class of people who are regulated in this situation. If you are not regulating everybody, it's not a rule. That is our concern here. The John Smith Production Company that comes forward is not bound by what happens in this application. That is our point and our position on this thing.
Okay, thank you, Mr. Pimpleton.
Thank you.
Mr. Daly, anything else you want to add, sir? All right. With the party's indulgence, I'm going to take a 5-minute break because I made the mistake of having a cup of coffee before I started this proceeding. So why don't we go ahead and go off the record, and we can go ahead and reconvene at 10:45. We're off the record.
That's fine.
Please. All right, we are back on the record. Let's take up the next issue in your motion for declaratory request as it relates to Sam's objection. Mr. Daly, next one I have is the Bryan Act does not require that a royalty rate on additional substances be determined on a unit by unit basis. Mr. Honey, I don't mean to be skipping over you as well, sir. If you have something to say, chime in. I've no doubt, I doubt sincerely that he is a shrinking violet. So at least I haven't gotten that since the last, whatever it is, 18 months that I've been doing these things.
Well, Mr. Honey's name is mentioned a couple of times in Mr. Perkins' briefs on this issue, and he will rise to explain and defend himself. And my presentation, as always, will be very short. And that is, you know, I totally agree that 5 companies could have filed 5 applications. And they would have been, as a practical matter, identical, except for the names of the applicants. And if the commission staff wanted to handle it that way, which I would expect they wouldn't, then we could do that. But there's nothing in the rules, certainly nothing in the statute, that precludes multiple applicants applying for potentially multiple units. And I think Mr. Perkins' argument, though clever, is that singular can never include the plural, which I think is also contrary to the rules of statutory interpretation, going all the way back to the English common law.
Well, in terms of that, Mr. Daly, the previous application that we had that was filed by SWA and Tetra was 2 companies and 2 Bryan units, was it not?
No, sir. It was 2 companies in 1 Bryan unit.
1 Bryan unit. I thought it was.
That one was somewhat unique in that the bromine in the unit will be extracted for the benefit of Lanxess Corporation, formerly Great Lakes Minerals Corporation. And Lanxess Corporation had contracted with Southwest Minerals, which is an affiliate of Standard Minerals, to first allow Standard Minerals to construct a pilot plant and then to commercially extract lithium only. But it's not 2 different units.
I may have been confused. I was looking at the. It's styled in the order itself. Right at the top, it says South Bryan unit and South Expansion Bryan unit.
It's two applicants.
Okay. All right.
The same unit. Here, we do have multiple applicants, each of whom intend to operate independently of the other, but who are urging the commission to decide as a matter of fact and a matter of policy that uniform methodology is the most appropriate way to go about this. Hence, they have filed a joint application, and the alternative would be to file separate identical applications with nothing different but the names of the companies.
Before I let you go, correct me if I'm wrong, but reading your application, Mr. Daly, or reading the application, you are seeking an order from the commission to set a lithium royalty for the Smackover limestone formation.
That's correct. The reason is that the Smackover limestone formation, which is roughly 2 miles below the surface, and varies somewhat geologically, is where the brine comes from that has been since the late 1950s productive of extracted bromine. And as a matter of fact, chemical analysis has shown since the beginning that there was lithium in there, as well as the salts, which the Tetra plant extracted in the application we discussed earlier. But changes in the world, including a need to operate vehicles electrically, has caused lithium to be of immediate interest now. The same formation.
Just one simple question, Mr. Daly. Is the Smackover limestone formation a brine unit?
No,
Okay.
no, it is a geologic horizon beneath the earth that, roughly speaking, is about 1,000 feet down. There are geologic formations, lots of them shallower and some that are in fact deeper. But it's in that horizon for reasons where there are a number of theories, but no positive proof. The salt water, which was within the formation, was particularly rich in chemical salts, making it prospective for extracting bromine and other things.
So within the Smackover limestone formation, there has been brine units and brine expansion units that have been established. Is that
Absolutely.
correct?
There are a total of 4 units at this moment, 3 of which are operated by Lanxess Corporation and date from the late 1989, 1990. I was counsel for Great Lakes Chemical when we formed those. And then the one very recently formed, where Secretary Curry served as the hearing officer, the Tetra Technologies Evergreen unit, which is formed, but it's not yet in production. They're still building. And then Albemarle Corporation, formerly known as Ethel Corporation, has been producing brine from the Smackover limestone formation since about the same time as the Great Lakes, since the late 50s. Albemarle Corporation has never is not true, has generally applied to the Oil and Gas Commission for the formation of units, because the leases also provide an avenue that a lessee can combine its leases without commission action, a voluntary pooling provision. And they didn't need to force pool unleased owners in their area. They had great success getting in their leasing activities, but they're still operating and they're still producing out of the Smackover limestone formation. And I think another one of the issues that Mr. Perkins raises, that I'll be glad to speak to when in time, is whether or not they are properly an applicant.
You're kind of leapfrogging ahead. We'll get to that in a second. I don't think I have any questions for you besides that, Mr. Daly. Thank you. Mr. Perkins?
Thank you, Judge. I don't have a lot to add to what I put in the response, but and I'm proud to know that Mr. Daly thinks I'm clever. My cleverness comes from reading the statute. If that's what he thinks is clever. In the statutory provision that we've cited over and over, the word units is referred to specifically multiple times, and it also refers to producers. Both of those are defined terms in the statute. Producer is the party who operates a unit that's been created by the Oil and Gas Commission. And a unit is exactly that. So the statute says, in addition to the amounts due and owing by the producer or producers of any unit to the owners therein, the producer or producers shall account separately and on a fair and equitable basis to each owner in the unit for all substances which are found by the commission to be profitably extracted from brine by a producer and which were not extracted by a producer on January 1, 1979. Now, when Lanxess and Arkansas Lithium filed their application last year for the hearing that it went to hearing on December the 5th, in their application, Mr. Daly and Mr. Honey, who were joined together, Mr. Daly represented Lanxess and Mr. Honey represented Arkansas Lithium. In their application, it states, the applicants request that any order entered by the AOGC be expressly limited to the South Brine Unit and South Brine Expansion Unit in recognition of the fact that the economics underlying the determination of a fair and equitable royalty will vary from one brine producing unit to another. Each brine producing unit has its own unique characteristics and should be considered on its own merits without this application and order being treated as precedent. It couldn't be clearer. At that time, they were taking the legal position that this is a unit by unit determination, but now their clients have changed their mind. And so they're urging you that what they said last year was just wrong on the law. And so, you know, I think we can recognize it as what it is. It's their litigation position that their clients want them to take. And it just defies the language of the statute.
I gather the clients are taking that position because it's a intentional method to be more efficient or expedient. I don't know. I mean, it's hard to tell what the shift has been. As I understand it, there is an expediency or an efficiency aspect to it.
And
I guess, I'm sorry, Mr. Perkins, go ahead.
well, I just wanted to add, I never claimed or argued that they could never join together in one application, so long as they included the information about their respective units. They haven't done that here. In fact, they're saying, well, we want this to apply to units, non-units, unintegrated areas, places we may or may not ever create a unit. We want it to apply to all of the areas where we own leases and all of the units that we operate.
Yeah, you jumped ahead to my question, which was, there'd be nothing prohibiting that I'm aware of to, let's just say for the sake of argument that these were individual dockets. As a matter of practicality, we'd probably consolidate them anyway, correct?
Sure.
Possibly. And along that same vein, if we had multiple companies and multiple units in one docket, you're not saying that that should be prohibited,
No.
are you? Okay. You're just saying from the perspective of applying a royalty to a formation, it's not contemplated by the statute.
Right, that's right. And that, you know, the requirement to determine profitable extraction and what's fair and equitable is going to be based, as they said last year, on the unique characteristics of each unit. If they want to join them all together in one giant application, there's nothing in the rules or the law that prohibits that.
So for the sake of argument, rhetorically speaking, if the co-applicants amended their application and included specific units, you wouldn't have an objection at that point?
No.
Okay. Anything else, Mr. Perkins?
Nothing else.
Thank you, sir. Mr. Hickey, anything you want to add to that?
Yes.
There's two things that I'd like to add. One is that since we're talking about lands outside of units, this adds to some of the due process issues raised in the objections. And then the second thing I would like to add is that the way that the statute is currently written, they should pay this additional consideration to people that are in a unit. Well, one of the co-applicants has taken the position that that's permissive language and that they're not in a unit. So therefore, someone could read that and say, we don't have to pay them for the lithium.
Well, they're trying to get a royalty, as I understand it, set for the entire formation. So if your clients have property within that formation, I think they're gonna have to pay if they extract that brine from anywhere within that formation, as I understand it.
That is correct, but it cuts both ways. So if there are unleased individuals in the same formation and they haven't been provided due process with these hearings, this royalty that's set here would be the default royalty.
Well, I can only make a decision on the here and now, not what may happen in the future, but I appreciate the argument. I do. Thank you, sir.
Thank you.
Mr. Pimpleton. I am particularly curious about the commission's perspective, or staff's, I should say, perspective on this one.
Well, the staff's position on this is that if somebody files an application on a unit asking for the 315C, and I guess I'll call it royalty here, the additional basis or method for how they're going to compensate, there is a unit component to this clearly, so they can determine who they have to pay. So there is a unit by unit consideration that has to be made when the commission enters any order to determine what's fair and equitable. So as it pertains to whether or not there has to be a determination based on a unit by unit basis, I believe that has to be done by the commission. However, it is possible that the same method can be proposed for many units. And I think that's what has been done here. You kind of stole my thunder earlier, but a lot of times when we have several different applications that are very, very factually similar and deal with the same legal issues, we do consolidate the matters to make sure that they can be dealt with.
Well, I think Mr. Perkins has already agreed with that premise in terms of, consolidation of companies, consolidation of units under one docket. I don't think that's the issue.
Correct.
But again, as I read the statute, it refers to units.
Yes.
I mean, throughout, it's units, okay? And this application doesn't mention a single unit, does it?
Well, it references
a formation, and the formation, as I understand it, extends way beyond what the units are within that formation. Now, I agree with you, the units are a component of that formation, but the formation is not a unit, right?
That's correct. The way that unit, I believe, is defined. Hang on.
Sure.
For a brine production, it means each separate composite area of land so designated by order of the commission for the production of brine and the injection of effluent. And that's in 302. So there is an aspect where the commission has to determine where you can produce brine.
But again, you've used the term unit, and this application doesn't want to set a royalty for a unit or any units, as I read it.
I believe
It wants to set it on a formation.
Yeah, I believe the commission is going to have to determine where specifically the brine production is going to occur, where the units are located.
Why is that incumbent upon the commission? Why isn't that incumbent upon the applicant to do that? Why should the commission have to do that?
I think it is incumbent on the applicant to demonstrate where the brine production is occurring.
Does this application do that?
They may produce that evidence at the hearing. As far as whether or not they have established evidence for that, I'm not sure. You're asking me what will be produced at a hearing, and I'm not sure.
Right, but I understand. I'm looking at it from an expediency standpoint.
Yes, sir.
And from the perspective of, certainly the commission does not want to enter an order that is ultra virtus, that's outside the scope of their statutory authority.
Correct.
Is there anything in the statute that says that they can set a royalty on a formation?
I do not believe so because of the way that brine production unit is defined.
Okay.
Here in the statute, I believe it's based on the unit. The way that 315C reads as well, the compensation is based on the owners in the unit. So the determination of where the unit is has to be made, or else if some royalty owner came to us in, we'll just say Miller County, and they said, we don't believe that we're being paid for the lithium that's being extracted. We have to know where the extraction is taking place to determine if there is some type of finding by the commission that they're subject to.
Mr. Pinkleton, the concern that I have when I read the statute and then I read the application is the commission unwittingly opening up Pandora's box
It would not
by
be
establishing a royalty on a formation when they've never done that before? They've always done it on units.
I believe that we would request specificity on where the production is going to occur, who is subject to the order itself.
Why not do that now? Why wait until the hearing? Isn't it at that point, isn't it almost too late?
It's never too late.
I suppose not, but we're going to convene for 2 days.
We've had many times, including the previous case you referenced, where things come up and need to be clarified. We would rather that be clarified with the complete gambit of the commission to consider and vote on that matter.
Right, that's essentially why I'm holding this hearing, is to get those clarifying points squared away.
Yes, Your Honor.
So we don't spend a whole bunch of time at the royalty hearing discussing procedural matters and then never get to the royalty. So I'm trying to provide them with a roadmap. And I'll ask, I'm sorry, Mr. Pinkleton, anything else you want to add?
No, Your Honor.
I appreciate it. Thank you, sir. Mr. Daly, I'm really wrestling with this one. I'm sorry, sir.
Well, I'm sorry too. Let me try to explain. The application requests that this rate, the requested rate, be applied to the units that they will form.
But it doesn't say that in the application at all.
Yes, it does.
Where does it say?
It does.
Show me. If I'm missing it, my apologies.
This is paragraph 17. Co-applicants believe that the design of mineral owner compensation should be as just detailed and so forth, and apply to lithium product derivatives manufactured from lithium ions extracted from the brine by any of the reference counties, whether in units or production areas.
What's a production area?
Production area is a voluntary unit that are the ones formed by Albemarle Corporation. They are very similar to units. But if I may answer the question, why don't we have units yet?
Let me stop you right there. Does the statute refer to production areas?
The statute does not refer to production areas.
Isn't that why you've referenced trying to, I mean, I just asked, you're trying to establish a royalty for the Smackover limestone formation. You told me yes.
Within the units or production areas operated by the co-applicants.
Well, why not just, and you know, in terms of the precedent, why not just amend what your application is, reference the specific units, strike the production area aspect of it, get a decision from the commission that's going to have precedential value throughout the formation, I would assume. Why do you want to go down this road
The
and
units
potentially
don't exist yet.
Okay, go ahead.
There are units, but they're not, all the co-applicants don't have units established yet. And it's very expensive. We're talking about an investment of in excess of $1 billion that these co-applicants have to decide whether or not they're going to make. And if we're told we can't even talk to you until you have formed your units, then the result is unfavorable. There's a lot more money wasted. what they are asking for and are hopeful that the commission would be willing to provide is guidance. This is what it's going to cost you in royalty when you do this. They want to take this step before the next step of forming the units. And it will only apply when units are formed, but they're asking for a decision as to what it's going to be then.
I'm sorry, Mr. Dealey, I respectfully disagree with that. I think it
Well,
applies before units are formed, because you're asking them to set a
You may
royalty
do
on
so.
production areas.
Obviously, you're the hearing officer, but I mean, here's what's going to happen. I would hope if that's going to be the decision of the commission, it be made before the 4th of November, so we don't all go rolling down to El Dorado with 3 days worth of hotels and turn around and come home. That's one of the reasons why we're having this hearing, hopefully, so we get some answers, so we know whether in fact we can proceed. But I cannot amend this application to apply to units that don't exist yet. They will exist.
Oh, I agree with that. I agree with that entirely. You can't amend it to units that don't exist, but you can certainly amend it to units that do exist. And if the commission applies a royalty, again, aren't they providing a roadmap to anyone else that's out there? This is what the royalty payment's going to be. You can decide. I mean, as Mr. Pinkleton said, I mean, you're going to have to provide them with some narrowing information at some point. Otherwise, it's inconsistent with what the existing law is.
I can amend it to describe the units that exist today. But the purpose of the application is for it to apply to the units that these companies form over the next 12 to 18 months.
Okay, I see. I appreciate and understand. I can't imagine that the commission would, after setting a royalty, and maybe that's the concern of the companies, but they would set a royalty and then somehow in another unit that's formed, set a different or a higher royalty. That's the concern of the companies?
That is a concern.
Okay.
And it should be a concern of everyone that the mechanism for calculating the royalty be applied uniformly across.
Understood. You want consistency, and I appreciate that. If I'm the company, I'm going to invest all this money. I appreciate or understand why consistency is paramount. I do. I get it. But unfortunately, the law is what the law is. And I see that as a problem. I understand what the companies want, and I appreciate why they want it. But I don't see how you can ignore what the statutory scheme is. I mean, it is very unit oriented.
That's right. And it will be unit oriented. But you're concluding, and I think erroneously, sir, that the unit has to exist before you can go further.
And I'll disabuse you of the notion. I'm sorry. I was actually the hearing officer that presided over the Tetra unit formation. So I understand, and I do. I appreciate the concerns. I really do.
And if this is going to be the result, please tell us before we all go hauling off to El Dorado.
Oh yeah. Oh no. It's no matter what, you may have an inclination by the end of today, or at the latest by the middle of next week. We're not going to wait until you run down to El Dorado. That would be fundamentally unfair to everybody in the room. That's why I'm holding the hearing, to give you sort of a guidance and a roadmap.
I understand.
Yeah. I don't play hide the ball, Mr. Daly, or try not to anyway. Mr. Parkins? Oh, sorry. I thought you were getting up, Mr. Oney. Sorry.
Nothing further, Your Honor.
Mr. Pinkleton?
Nothing further.
Mr. Hickey? Ms. Clegg, my apologies. I have been overlooking you throughout this hearing. I do not know whether or not you want to chime in on this one or not.
Thank you, Judge Middleton. Not at this time. Thank you.
All right. And again, I apologize. I was hopeful and optimistic that if you had something to say, you would speak up.
I will. Thank you.
Thank you. All right, let's take up the next point. And that is, Mr. Daly, you were looking for a decision that Albemarle has standing to participate in this docket and in the application.
Sorry, I've got to. All right, I'm going to turn my search engine back on, if I may, and I'm going to search the statute for the word producer. And the definition of producer is in the definition section, which is 76302, subhead 12. Producer means the owner of an existing well or wells capable of producing brine, as well as any other owners who are capable and willing to incur the capital investment required to do so. The last part being a paraphrase. So if we look at the 31 matches of the word producer in the statute, we see that it refers within the body of the statute, the requirements of the statute, it refers to producers 31 times. And
this is in the Brine Act?
Sir?
This is in the Brine Act?
This is in the Brine Act.
Okay.
I converted the Brine Act to Microsoft Word so that I could search for words, and which I'm sure what Mr. Perkins does as well.
Mr. Taylor, this is a little different than the way you've couched this in your motion, though. Because you never mentioned anything about producers. Your argument in the motion was along the lines of
Albemarle in just a minute. What I'm going to tell you is that Albemarle is a producer.
All right.
Albemarle meets the definition of producer that I just read you.
Well, again, I'm not disagreeing with you, but that's not what you raised in your motion.
But, well, the motion is that Albemarle is a proper applicant.
Well, your motion was that they don't have any prime production areas that have been unitized, but you contended that Albemarle's lithium leases, which I gather incorporate the provisions of Arkansas Code annotated 1576-315 as a contract provision, result in Albemarle having standing to participate in the hearing.
That's right. They are an interested party and they are a producer. And the statute permits interested parties and producers, requires producers to pay the additional royalty on the extraction of additional substances. Moreover, they become an interested party contractually because each and every one of their leases requires them to adhere to Section 315. The argument to the contrary leads where you don't want to go, and that is if they're not bound by this statute, they don't have to pay royalty. And I don't think.
Well, they do. They got a lease that says
they have leases, but the leases call for them to pay the royalty that the commission sets.
Right.
So they're an interested party.
Well, again, that's couched a little differently than the way you had pitched it in the motion.
I think that's about what I said in the motion. Maybe you better go back and look at the motion again.
It was your shortest version in the motion in terms of they abstaining because they get a lease that incorporates the act.
This is such a silly argument that it doesn't require a great deal of analysis and words on the page. Why do these owners not want Albemarle bound by this. What, do they want Albemarle just to be turned loose to go off and do whatever it wants to do? I don't think so. I think they're just trying to figure out another way to wreck the train.
Well, I think you used the term harassment in your motion. But if adherence to the law is harassment, then
Well,
so be it.
Albemarle contracted to pay the royalty that's prescribed by the statute. Therefore, they are an interested party. Interested parties are entitled to file applications in the
Let me
commission.
stop you right there, Mr. Daly. So the landowners that sign those royalties are also interested
Absolutely.
parties.
Landowners.
Do they have the right to petition the commission to set a royalty under
Yes,
your
sir.
theory?
Yes, sir. Absolutely, they do.
That's an interesting argument.
I don't think there's any argument about it. I think if
Okay.
they're an interested party, they have a right to petition the commission to file an application, set a different royalty.
Has that ever happened before in your experience?
No, but
Okay.
it doesn't mean they can't. All of this is pretty unique, as you know.
Yes, it is. Otherwise, I wouldn't be here doing this.
Yeah.
Okay, I appreciate it. Thank you, Mr. Daly. Mr. Parkins. Oh, wait a minute. Yeah, I'm sorry. Go ahead, sir.
Well, I'm sorry that Mr. Daly thinks trying to follow the statute is silly. That's what lawyers say when they can't really meet your legal argument. He sort of paraphrased the definition of producer, but let's look and see what it really says, because he left out a pretty critical part of it. Producer, this is in Arkansas Code annotated 1576-302-12. Producer means the owner of an existing well or wells capable of producing brine, as well as any owner or owners who are capable and willing to incur the capital investment required for purposes of drilling, completing, and equipping the proposed well or wells. And this is the part he left out. Within any existing or proposed brine production unit. That didn't really fit his argument, so he left that part out. And then he said, and you know, gosh, the royalty part, the additional substances applies to producers. And so, you know, they're a producer and applies to them. But as we've already read numerous times today, the Arc Code Ann 1576-315 C1 refers to the producer or producers of any unit. It's not just producer, you know, whether or not it fits the definition of the statute.
And you're cobbling together producer and unit as it relates to accounting royalty.
Correct.
That's the verbiage.
Exactly.
And I'm caught a little off guard because, again, as I read the motion, I never saw the word producer in the motion or in the reply. It was always along the lines of they have these leases and therefore, and the leases incorporate the verbiage of the Brine Act and therefore they're an interested party.
Right.
What about Mr. Daly's argument that landowners who also are interested parties would have the standing to petition the commission for a royalty?
I don't even, in fact, I stated in my response that I don't have any objection if Albemarle wants to come to the commission and ask for a voluntary ruling on what the commission believes is a fair and equitable royalty rate on lithium for their voluntary production area. And they provide all of the necessary information to determine profitable extraction and have the commission do that. Since their leases call for it, I wouldn't have an objection to that. But it's not a statutory duty or authority under the Brine Act because it applies only to producers of units.
Thank you, Mr. Perkins. Mr. Hickey. Thank you, sir. Mr. Pickleton, again, I'm curious in terms of what staff's position is on this one.
Well, Your Honor, I do have to admit again, I think it was brought up earlier, I've never seen any of the leases outside of what has been presented, I believe, as pre-filed exhibits.
I have another, Mr. Pinkleton. I am taking it on faith that what Mr. Daly has said about what the leases say is accurate. I don't have any reason to disagree or dispute it. again, the threshold issue that I am wrestling with is a lease sufficient to grant standing? Now, there's absolutely no doubt that Albemarle has an interest in this.
Yes,
Everybody in the room has an interest in it. The landowners have an interest in it.
yes.
The General Assembly has an interest in it. The communities in El Dorado and Camden, in Magnolia have an interest in it. There is a humongous amount of interest. But does interest translate into standing to request a royalty under the four corners of the law?
On a lease agreement, I would say that the mineral interest owners here have at least a pecuniary interest in what is being done here. So from that standpoint, if the affected parties want to agree that there's jurisdiction, the commission staff has no problem with one of those parties coming before the commission to ask for some type of adjudication through an order once an application is presented. If somebody is directly affected, as part of our way of protecting the correlative rights of the folks who would be adversely affected if they were not given the opportunity to come before the commission and have that issue adjudicated.
Well, but the statute doesn't speak to interested parties. It speaks to producers of units, right?
Right.
I mean, it doesn't, the statute doesn't stretch to interested parties. Again, the concern that I have is if I agree with that, what are we opening up here in terms of, does the commission want to start, receiving applications from lease landowners that sign leases for royalty determinations? Have you ever done that before?
Yes, and that was actually something I referenced earlier on one of the other issues when I was
Okay.
talking about. I do not believe, since I've been here, I have not specifically addressed whether or not a brine royalty interest owner could file a royalty complaint under our oil and gas statutes, because the word brine is not used in the oil and gas statutes. It says specifically there you're an oil or gas mineral interest owner or something to that effect. It doesn't go into the different type of mineral. When we have somebody who has a lease or is subject to an integration order or some other type of legal requirement where an operator has to pay a royalty for the production of oil or gas, the statute is clear that they can bring a royalty owner complaint to us and we have to investigate it and make a determination. You're asking whether or not the Brine Act addresses that, and I don't know for sure because there's not that specific statute.
Well,
But it does say that
that's apples and oranges in terms of what we've got here, though. I mean, I'm not disagreeing that a landowner that signed a lease has standing to come in and complain that the terms of their lease aren't being upheld by the producer.
But what about if they have a lease and they don't believe they're being paid accurately or the method is not good?
Yeah, they certainly have standing. That's a different animal in terms of having no royalty whatsoever and having a landowner who has signed a lease petition to apply to the commission for the establishment of a royalty. I guess, is that contemplated by the statute? In terms of, we're talking about producers of units. Right?
Correct, but the other interested parties that are referred to with that duty to account are the owners in the unit. So the owners in the unit, clearly, if they have agreed that everybody's going to be subject to the statute, they're the only other ones really who have the standing in this situation, because they're the ones that have to get paid accurately or paid fair and equitably, I guess is what I'm saying.
Right. How about if I just cut to the chase? Is it staff's position that Albemarle has standing to pursue a request for a royalty in the absence of the fact, which has been admitted, they do not have an established brine production unit?
I would say yes for two reasons. I believe that the leases are able to afford the ability for the commission to hear the matter, but I would go a little bit further. There are at least two cases that I'm aware of, two docketed matters where an order was found by the commission regarding Albemarle's operations.
And what are those?
They are docket 070-2017-06.
Oh, hold on, Mr. Pinkleton. I'm slow here. Say again now.
070-2017-06,
-46,
2017-06, meaning it was
2017, wait a minute, 070-217-06,
06, meaning it was
Okay.
filed in the June of that
Okay,
year.
what's the other one?
The other one was earlier this year, 040-2024-07.
040-2024
07.
07.
And I believe you were the hearing officer in that second matter.
If it was 2024, I'm sure I was.
I think I was there too to enjoy the show.
So both of these cases stand for the proposition that,
well, in both of those situations, Albemarle came before the commission to address, to some degree, their brine production in some of their fields. Now, the question that came up during this briefing is, has Albemarle filed or formed a unit by application through our process? And I do not believe that they have filed an application and had the unit found through an application itself.
I think that's a given because that's already been admitted by counsel.
Yes.
Right.
But through other applications that they have filed with the commission has determined through a defined area where they can produce brine. And I believe under the definition of a brine production unit, once the commission issues an order that finds in a defined area where you can produce brine, you have a brine production unit. So to some extent, they have a brine production unit with the commission where the commission has issued an order and made findings. They have standing in this situation to deal with brine production. They did not file or form the unit through an application, but they have through other means formed a unit with the commission. The commission has found so.
How does that circle back to your earlier assertion that the act says or applies to units, brine units, and that at some point in time, the co-applicants in this docket are going to have to show their cards and say, okay, here's the units that we're talking about. If that's the case and Albemarle doesn't have a unit, how do you cobble those together?
Albemarle is going to have to show where this field is, where the production's occurring, and who's going to be affected by the brine production, who is subject to that additional payment. They're going to have to demonstrate that to some degree, to some certainty, so that we know who would be regulated.
But they haven't done that yet.
They haven't done it through an application.
Okay.
But they have had an order issued in 2017 saying where their brine production wells, or at least they had the authority through the commission to have those wells permitted. And they also came here earlier this year to establish that they have not profitably extracted brine in their west field, roughly 21,000 acres. But they also had a finding that they could set up a pilot plant to produce brine, but not profitably extract it.
Again, that to me, that seems like it's apples and oranges. You're talking about brine production. We're talking about the establishment of a royalty for lithium.
But they have, through other means, established the unit. The unit gives them standing at that point to present something before the commission. The concern here was that they did not have standing because they did not form a unit through application. And they have not done that, but they have a unit.
Okay. All right, thanks, sir. Mr. Daly?
Calling your attention to a portion of the statute, specifically 1576-307F.
I'm sorry, Mr. Daly, what was that again?
1576-307, parenthesis, lowercase letter F.
Okay.
Any interested party shall have the right to have the commission call a hearing for the purpose of taking action in respect to any matter within the jurisdiction of the commission by making a request therefore in writing and paying a filing fee. Albemarle clearly is an interested party.
Okay. I appreciate that. Thank you, Mr. Daly. Mr. Perkins?
Nothing further, Your Honor.
Pinkleton, anything?
Nothing further.
Vicky?
No, sir.
All right, last item on your motion for declaratory order has to do with the Bryan Act does not require the Arkansas Oil and Gas Commission to wait until an additional substance is extracted before determining a fair and equitable royalty on the additional substance. Have I stated that one correctly, Mr. Daly? Is that what you're looking for?
Let me start by attempting to correct some misunderstanding about the profitable extraction portion of 1576-315. If you read that in context and you wanted to make sense as to what the legislature was talking about, there was a concern that we're setting this royalty for bromine. But what if they produce something else? How are the royalty owners going to get paid? And the answer is, well, if they extract something else, but it's not profitable, then you don't have to pay them. And that in fact goes on. The brine wells are in old oil formations and they continue to produce minuscule quantities of oil, which has to be removed from the brine before the brine is processed or it'll gunk up the equipment. They get to keep that oil because it costs more to take it out than it's worth. They also produce lots and lots of natural gas. But that natural gas is so full of sulfur dioxide that the cost of cleaning it up exceeds its value, so they don't have to pay royalty. But if they were to extract something that is profitable, then they would have to pay royalty. And that's for the benefit of the royalty owner. And so the royalty owners, I would expect the royalty owner to say, well, you're making lithium and that's profitable. Therefore, you should have to pay a royalty to be set by the commission. But what the objectors are doing is they're turning this around and they're saying, you've got to prove that you're extracting profitably, or you've got to prove that you're going to extract profitably. And this does get into the motion to quash, because what they really want is to get into your secrets. They get to get into your confidential information and your processes and all of those things, which we're going to explain in a minute is a violation, is going to cause us to violate the federal antitrust laws. But the idea that, and other than maybe the companies will say, we stipulate that we fully intend to make a profit. That should be enough, because it's not our burden to prove that we're making a profit. It's the royalty owner's burden to prove that we're making a profit. Because if we're not making a profit, we don't owe them anything.
Oh, hold on a second, Mr. Daly. So the co-applicants have filed this before the commission, and they're asking for the establishment of a lithium royalty. The co-applicants bear the burden by a preponderance of the evidence, I believe, to the commission that this royalty that you were suggesting is fair and equitable.
Correct.
Isn't that the nut of it?
Correct.
Okay. Go ahead, sir. Sorry.
But I don't think they bear the burden of coming in with economic proof that they're going to make a profit. They're going to say that they're going to make a profit. We cited some specific language from the commission's adjudication of that SALT hearing in 2007, where this very issue came up. And the answer was, they said they're going to spend $100 million. They wouldn't do that if they hadn't intended to make a profit. the application was approved. It's as simple as that. I think that over time, there has been confusion arise about what's the chicken and what's the egg here. But I don't think it is, I don't think that the applicant have got a burden to come in and prove that they're going to make a profit. I think they're going to admit it. They're going to confess that they're going to make a profit, therefore they owe the royalty. That's the whole.
I understand. Thank you. Mr. Perkins.
That whole discussion was just hogwash. Mr. Daly stands up here and says, it's the royalty owner's burden to prove we're making a profit. Now, how are the royalty owners supposed to do that without any economic information or leasing information?
Well, at least under the four corners of this, I think you already agreed that it's the old co-applicants that have the burden of proof in terms of this particular hearing that's going to be held hopefully on November 4th and 5th.
And first, they restated our argument because they wanted to make it easier to rebut. We never said that the Brine Conservation Act requires the commission to wait until lithium is extracted before determining fair and equitable. We never argued that here, and we didn't argue it last year when Lanxess and Arkansas Lithium brought their application. But
can I stop you there, Mr. Perkins, if I might?
Of course.
So looking at ACA 1576 315C2, says whether or not any such substance is extracted profitably shall be determined by the commission on the basis of the value at the time of extraction without interest after deducting all costs of producing and recovering the same. What in your mind does that mean?
It means exactly what
it says.
The commission and the hearing officers and the lawyers have always agreed until now that it means. That the first step is the commission must determine that there is or will be profitable extraction. And that's done with economic information.
Well, what about Mr. Daly's point that when this issue came up in the previous Brine hearing, there was, I guess, discussion at the tail end of that hearing. One of the commissioners, at this point, I can't remember who it was, expressed a concern about profitable extraction. Chair Morledge said, hey, they're going to spend $100 million. Nobody's going to do that and not make a profit. We should just move on. And then I think one of the other commissioners said, I think the royalty that's being offered is pretty generous. And then they voted. Is Mr. Daly right?
He's right about what they said, but the commissioners are not lawyers. They make decisions based on what's before them. And as previously in discussion here today, whether what they decide in one application isn't binding on them the next time that an application is filed. But in that same 2007 SALTS hearing, here is what the hearing officer, who's now Secretary of Energy and Environment, Shane Corey, instructed them about the law at the beginning of their adjudication. He said, my opinion is that you as commissioners are supposed to do two things according to the statute. First, I'm jumping out of order of the statute. The first thing is you have to decide whether or not the substance is extracted profitably on the basis of the value at the time of extraction without interest after deducting all costs of producing or recovering the same. Assuming, or if you determine that it's profitable, then you just have to decide if it's a fair and equitable basis. And then, Your Honor, with all respect, last year in the hearing for Lanxess and Arkansas Lithium, you said essentially the same thing, and Mr. Honey agreed with you. And so, there's never been any disagreement about this issue until now.
Well, I don't think Mr. Daly's disagreeing with what the statute says. I think everybody's on the same page with what the statute says. I think the disagreement is what does the commission need to make that determination?
Well,
Mr. Daly says he's gonna have some people come in and say, we can, we've done the analysis, we can properly abstract it. I don't know what that evidence is gonna be. I couldn't tell you, because I can't tell from the application, right?
well,
But there's gonna be some of a showing, because I agree with you, the commission has to make that threshold decision. Can it be properly extracted? Now, whether or not, what information they need or want to make that determination, I don't know.
well, we know this, that in December of 2023, the commission heard extensive economic testimony from Arkansas Lithium and Lanxess, and a 200-page or however long it was feasibility analysis that included economics, geology, these are the expenses we expect. This is how profitable we intend it to be. And the commission decided that it still could not decide about a fair and equitable royalty because there was one document that contained some unspecified financial information that they did not have. And so they tabled it and said, we can't decide that until we get all of the economic information. There's absolutely no reason to think that they've changed their opinion about that from last December until now.
Well, is it possible because the four corners of the application has been changed or altered that it's sufficient at this point? Again, I can't speculate on what the commission may or may not want. I agree with you. We were on the cusp of establishing a royalty payment, and the commissioners in that December hearing decided that they didn't have enough financial information, so the whole thing was tabled. And then we were supposed to do it this year in April, and then eventually it was withdrawn, and so here we are. I wish beyond belief that we had gone forward with that, but we did not, because we would certainly have a roadmap at this point.
And in that instance, I even stipulated on the record that we agreed they had established that it'd be profitable production. It was the commission on its own that made that decision because in their minds, they didn't have enough. And right, I don't have a crystal ball. Are they going to look at this application differently? I don't know, except that history would strongly indicate no.
All right, thank you, Ms. Perkins.
Thank you.
Mr. Hickey? Thank you, sir. Mr. Pimpleton?
Yes, Your Honor.
Again, Mr. Pinkleton, I am just wondering what the status position is on this one.
I believe Mr. Perkins and Mr. Daly have given a pretty robust history of how the commission in previous hearings has dealt with this matter. And I think to some degree, we've seen where the commission in the 2007 matter took these two issues on profitable extraction method in a different way than how it was handled in December of 2023. I don't think the statute says clearly that you have to prove one of those things before the other as far as that goes. Profitable extraction triggers when the accounting has to be done on a fair and equitable basis. It doesn't say you have to do profitable extraction before the method or vice versa in that situation. The commission has clearly gone both ways on this. I don't think the commission staff can really speak for how the commission wants to address these and in what order.
Well, that's fair.
Thank you.
Again, as Mr. Perkins said, we don't have a crystal ball in terms of what they may or may not want. We can just go by. Apparently, they were unsatisfied in the last hearing with what they were provided.
Yeah, what commission staff does not want to do is make assumptions. The commission here, there's precedent from both sides. I'm not sure how they want to address that. They both need to be proven at some point. What order they take that in, we can't really comment on that.
All right, thank you, sir. Mr. Daly?
I will be repeating myself to tell you.
All good lawyers do, Mr. Daly.
Well, I try not to. Life is short. I will tell you that the co-applicants, each and every co-applicant will stipulate that it intends to make a profit if and when it extracts lithium. And that therefore there should be no doubt as to whether or not it has to pay for the additional substance. And I believe that is adequate under the law, under the statute. If we were denying we were making a profit, maybe we'd have to argue about it. But there are reasons that we'll get to in a minute with the motion to quash why we don't just open up the books. And therefore, we simply say the conclusion of this is we will make a profit. And I believe that's adequate.
Mr. Daly, Mr. Daly, I'm sorry. Do you have any concern about the information that's provided in this application that you would be going through this process again and the commission would be not satisfied with what the financial information that you provided?
We'll have to deal that when it happens. We're going to explain to you when we get to the next motion why these companies would be violating the federal antitrust laws if they produce the information that Mr. Perkins wants. And also why, as a practical matter, it's just not a good idea. But that's the next motion.
Yes, sir. Perkins? Pinkleton? Mr. Hickey? Oh, you're gonna chime in this time. Go ahead, sir.
The only thing I'd like to point out is that at the previous hearings for the determination of royalty, the SAMA objectors hired an economist, reverse engineered their reports, and showed that a 12.5% royalty would still net them something like 20% year-over-year returns. And I think that this is a self-serving argument that they don't have to show their numbers. Thank you.
Thank you, sir. All right, it is on the cusp of noon. I have no idea how long the motion to quash arguments are going to last. Do council want to press ahead and try to knock this out, or do you want to break for lunch? Everybody's nodding that they want to press ahead. All right, come on up, Mr. Daly. Let's get into the motion to quash.
My part is going to be very short, but
You will have a Zoom presentation for most of it. My part has to do with relevance. One of the things that has been requested and is covered in the subpoenas is leases taken by the co-applicants or any of their affiliates, independent landmen, et cetera, et cetera, et cetera, over an area which includes Northwest or Northeast Texas. I agree that leases within the 4 counties taken by these applicants are relevant. Taken by these applicants, at least. I cannot imagine what Northeast Texas has to do with any of this. I think that's overreaching. The commission has a policy that they've actually turned into a rule, which I think is A2, but I could be wrong about that. That when you apply to formate and integrate in the oil and gas context, you've got to reveal the leases that you're aware of in the unit. We're willing to reveal the leases that we've taken in 4 counties. But
have you done that yet, Mr. Daly?
It would be at the hearing. He's asked for a witness to talk about that. We'll have a witness to talk about that. We object to having to talk about East Texas. East Texas doesn't have the Arkansas brine statute. East Texas doesn't have any production of brine whatsoever. And indeed, if you read the law review article that I cited in the brief, there is uncertainty in East Texas as to who owns brine in the ground. Is it the surface owner or the mineral owner? Or does it matter whether or not it's produced independently or produced as a co-product of an oil well? There's obviously a lot of things going on in East Texas that are not going on in Arkansas that make East Texas leasing irrelevant. And the other thing that they request, I can't imagine the relevance of, is bonuses and other lease terms. We're perfectly willing to talk about the royalty clauses of those leases. But this is not an integration where the commission is going to require the applicant to pay a bonus. Therefore, bonus is irrelevant. Okay. That's a fairly minor point, but you know, I think it's a point to be made that we need to confine the testimony at what I anticipate is going to be pretty much of a marathon hearing anyway to relevant objects. All right, now Mr. Welford is on Zoom, I hope still, and he will discuss the applicability of the federal antitrust law.
Okay.
Good morning, Your Honor. This is Phil Welford. I should be coming up there you go. Perfect.
You are?
Somebody is well in charge of the system. So my role here today is just to talk about antitrust. I'm a former antitrust enforcer with the Department of Justice Antitrust Division. I practice antitrust law exclusively, government-facing investigations, antitrust law exclusively with Vincent and Elkins here in Washington, D.C. What I'm going to talk about is broadly two areas. One is what the antitrust law and antitrust economics says about the information that's been requested from the subpoenas. And what it says is sharing it between producers is a very bad idea for the competition. So that's what Tom Daly described as the practical part of it. The antitrust law, antitrust research agencies, and all the rest have made it very clear that they've looked into this and they said, don't put this into a public forum. That is very bad for competitive markets and consumers ultimately. And as a second point, obviously very much related, that it exposes that producing it publicly would potentially expose the producers to antitrust investigation by the agencies and to antitrust litigation, lawsuits, claims, liability, and such. I'm going to discuss the antitrust laws and also the two exemptions to those laws that are discussed in the briefs. Those are called the Noor-Pennington Doctrine and the State Action Doctrine. Those are very powerful affirmative defenses to antitrust laws. That much is true, and that has been mentioned. But they are very much narrower than the casual observer would expect. They're very fact-specific and very narrow. This powerful but narrow point is one I'm going to come back to in a moment. But first, because the fact-specific point is so important, I'm going to talk about the facts first. And I'm going to, at various different points, I think, skip over some of the facts because I think they've been well covered here. They're familiar to you, Your Honor. But stop me at any time if you want me to drill down further into the facts, and Tom Daly can help me with those. The data, moving to the factual part of it, again, trying to move briefly through it. The data that's sought by the subpoenas is extremely competitively sensitive information. This is a term of art in antitrust law and antitrust competition economics, CSI, competitively sensitive information. We've defined it in the briefs. But I don't think there is any debate that this information is CSI. It includes studies and analysis, forward-looking information, as well as past-looking information, assignments and related contracts. Those are the language of the subpoenas themselves. And what it would get to is information on cost, production plans, business strategy, supplier relationships, technology and other trade secrets, and even customers and pricing. This is keys to the kingdom information, sort of the holy of holies, if you were in church and talking to a Catholic priest. This is the kind of thing that companies are not permitted to share with each other without leaving themselves open to tremendous antitrust problems. The antitrust authorities strongly prohibit the sharing of this kind of detailed information, CSI, competitive sensitive information. As the citations show in our briefs, the Federal Trade Commission and DOJ Antitrust Division frequently warn companies that they must not expose this kind of information to their competitors. I can go into the full policy reasons. There's 3 buckets of policy reasons that the agencies mention, but in the interest of time, I'm going to skip over that unless you'd like me to elaborate, and you can raise your hand at any time and ask me to, but
fine. Go ahead and skip over.
This is not a general vague concern about competitively sensitive information in general. This is very directly and explicitly a concern about mineral lease and mineral production competitive sensitive information. In the mineral lease context, repeatedly, the antitrust agencies have said, do not share this information, do not put it into a public forum. If you're a member of a trade association, for example, under no circumstances should that trade association publish it. We will go after you if you publish it. And if you do some sort of wink and a nod thing and say, well, a trade association asked me to, or a low-level official at a local government asked me to, and therefore I was forced to do it, they will say that doesn't qualify as state action. You didn't push hard enough to keep this stuff secret. You are sharing the information and you are in trouble. There are consent decrees, very recent ones, even last year, one that I was one of the lawyers who worked on and had to fight with the FTC about, EQT Quantum Tug Hill, for example, that's mentioned in the briefs, where the Federal Trade Commission prohibited the parties from sharing either with each other in a merger context or with anybody else that was a producer, this is an appellation involving gas, any of their mineral leasing and mineral production information. They said, we think you guys have done it occasionally in the past. We're hitting you with this consent decree and some consequences, and you better not ever do it in the future, or we will hit you harder. As we mentioned again, I won't go through all the cases, but to emphasize exactly how dangerous it is, in the Permian Basin leasing cases, again, mineral rights, mineral production information, that led to lawsuits against oil and gas producers all over Texas and Oklahoma, and even the criminal indictment of the CEO of Chesapeake Energy Corporation, Aubrey McClendon. So if the question is, why does Tetra and the other producers worry about this kind of thing? Well, when a CEO is criminally indicted, that gets people's attention. It's very serious. And again, it is absolutely involving mineral lease information. This isn't a general and inchoate concern about the various different industries. This is specifically about mineral lease information. Turning now to the antitrust exemptions, we can knock one of them out very quickly. Some of the briefs have mentioned the Knorr-Pennington doctrine. These are 2 Supreme Court cases. They're always mentioned together, Knorr and Pennington. SAMA does not understand or discuss Knorr-Pennington quite correctly. Knorr-Pennington is an extremely powerful exemption, but it is an immunity for lobbying. It is an immunity for political petitioning of the government for particular redress. For example, Knorr-Pennington does apply in this proceeding. It applies to the landowners getting together and saying to the state of Arkansas, please give me a higher royalty rate. We would all like that royalty rate, and we collectively think that royalty rate should be X or 2X or 3X. If you got together as sellers of a royalty rate or sellers of anything else, and you collectively said, I want to fix prices, that would be illegal under the antitrust laws, in fact, criminal. But they're allowed to do that if what they are doing is purely getting together and saying that to the state of Arkansas. So Norm Pennington does apply there, but Norm Pennington is not the right immunity for the sharing of huge amounts of competitive sensitive data with each other if you're commercial entities. That is not part of the lobbying that these producers are doing. In fact, they don't want to do it at all, but that is not immunity for lobbying. That's not approaching a senator. That's not off the rest of it. It is that's just the wrong exemption. The right exemption to discuss is state action, and there has been some discussion about that. So that's where I will spend the rest of my remarks. The subpoenas do not appear to be state action because they are not what is called actively supervised. And actively supervised is a term of art in the antitrust laws. It's well covered by various different Supreme Court cases, including the one I'll mention most in the briefs was North Carolina Board of Dental Examiners. The commission, the actual Oil and Gas Commission itself, did not draft these subpoenas. That's the first point. The drafting was, in the language of the North Carolina Board of Dental Examiners, essentially delegated to a non-sovereign actor. I understand that Your Honor signed these subpoenas, but I think it's safe to say that Your Honor didn't come up with them. They were suggested by SAMA, again, which SAMA is allowed to suggest under Norm Pennington, but the results of those actually applying to them, that implicates the state action doctrine. And when Your Honor sat down and signed that, that's what's called use of stationary rather than active supervision. The commission did not write them, did not come up with that idea. And even more importantly, it didn't do the following. If you're going to actively supervise, if a government entity is going to actively supervise a state action that has the tendency to replace ordinary competition, which in this situation would be, as the Department of Justice Antitrust Division has said, don't ever share this stuff, then you have to make a finding that your intention, that the commission's intention is to replace the antitrust laws and the benefits of normal competition, in this case, as to information sharing, with a different regime, and very importantly, that the intention of the commission is to accept the consequences, both economic and political, of eliminating competition with a price-controlled or other controlled scheme. The phrase that tends to be used here is usurp and replace the competitive process or the ordinary functioning of the market. And again, that's not as to the royalty. The royalty is a separate question that's covered by lobbying, this lobbying exemption, Norm Pennington. What I'm talking about usurping and replacing is as to this large amount of competitively sensitive data. The commission could do that. The commission could hold a hearing and say, we have decided that despite DOJ and everybody else saying this is a bad idea to share this stuff, we think it's a good idea to share this stuff. We're going to cause it to be put in and published. But the commission has not done that. And please understand, I have every respect for this hearing, but this hearing does not appear to have the ability to do that. That is a commission decision to make rather than a hearing officer commission to make. Obviously, you could make a recommendation of any kind to the commission, but that would be something the commission needs to do to usurp and replace the competitive process. There's no assumption in the antitrust law that a private party, even if they are, so to speak, little guys, that they are little guys going after big corporations. There's no assumption that the little guy is able to understand something better than a competitive process. The Supreme Court recognizes that the function of a competitive market and a competitive process is sort of the highest policy goal, regardless of whether people are big or little, large or small. So let me go now to explaining exactly how the brine companies would be exposed to antitrust risk here. if the brine companies disclose to each other all of their CSI, competitively sensitive information, such as pricing, leasing, operating costs, everything else, there's a risk that that will be treated as an exchange between them of commercially sensitive information because of this unusual situation in Arkansas where the companies cannot submit it under seal or individually or redacted or any of those things. My understanding is it would be public. And being public, it is just as good as handing it over to your rival, which you're clearly not allowed to do.
Let me stop you right there, sir. Why can't the companies redact sensitive or confidential information?
My understanding is that to do so, it would essentially be a blank set of pages. The information that has been requested here, and Tom Daly, you should jump in. I have not had the direct discussions with Mr. Perkins. Tom Daly has, so he may need to jump in here. But my understanding is Mr. Perkins genuinely wants everything that has been requested here. If there is a way to, between Mr. Perkins and Mr. Daly, work out some lesser version of the subpoena, we may be open to that, but I haven't been part of those discussions.
I don't even think there's been an attempt. Let me ask you this. Are you familiar, sir, with the Oil and Gas Commission subpoena powers?
Yes, I am.
Okay. You understand that essentially the commission's subpoena powers are a paper tiger, do you not?
I'm not sure what you mean by that. You mean?
All right. Well, I don't have the ability to, or neither does the commission, to force the co-applicants in this case to adhere expressly to the terms of that subpoena. If enforcement is necessary of the subpoena, the commission has to go to circuit court to get that enforced. So the co-applicants in this case are free to comply with it or not comply with it at the administrative level. You understand that, right?
I understand that if we do that, if the co-applicants do that, then it would, and Mr. Perkins or the commission decides to try to enforce it, then there would be another step. In other words, it's not instantly enforcing. Yeah.
Mr. Perkins doesn't have the ability to enforce it. It's only the commission. And they have to go to circuit court to do it.
Okay. So if I'm understanding what you're suggesting is that our argument about the merits and the antitrust concerns can be made. This is a question in the form of statement to you.
Well, let me ask you this. So we're talking about 3 federal antitrust laws, right? We're talking about the Sherman Antitrust Act of 1890, correct?
It's primarily Section 1 and Section 2 of the Sherman Act. That's right, 15
Right.
U.S.C. 1 and 2.
Clayton Antitrust Act of 1914, Section 7.
That's
Yeah.
about mergers and damages. So that's less.
Well, I mean, it was mentioned
Yeah.
by Mr. Daly in his motion.
Yes, but all of them sort of collapse down to Sherman 1 and 2 as the others do not really provide a whole lot else than Section 1 and Section 2 do.
Has anyone ever been indicted for sharing information with a state agency?
Yes.
Okay, they have.
Yes. The Department of Justice Antitrust Division has a whole series of cases that are what I was calling misuse of stationary cases.
Okay.
For example, there are many cases by realtors, sellers of homes, real estate agents, who have dominated state realty boards and have caused those realty boards to essentially do the bidding of the realtors to allow them to share information. And that's sort of wink and nod stuff as, oh, I got this subpoena from them, or I got this document request, and therefore it said I should hand it to all my competitors, and I did. And guess what? That caused them all to set their house commission rates at 6% firm, which is what the Department of Justice does not.
Right. So to your point here, there are basically 5 broad categories of antitrust violations, and I am broad brush here. You get bid rigging, horizontal price fixing, vertical price fixing, monopolization, and anti-competitive mergers, right? Are those the 5 broad categories?
That's one way to say it, yes.
Okay. So explain to me, if this information is shared with the state agency, is it going to result in bid rigging by the co-applicants?
There's 2 types of problems that we would be accused of. So we are not planning, I can absolutely tell you that I have not been told to enable bid rigging. Absolutely
Okay.
not. But the problem is what we can be.
How about horizontal price fixing? Sharing that information, is that going to result in the co-applicants engaging in horizontal price fixing?
What we absolutely are not interested in doing that. However, we can be accused of it if we have the opportunity from the information. What we are concerned about is being investigated and accused of that.
Well, you can be accused of anything, but they still have to have the evidence that this type of collusion or activity took place.
This would be the evidence that it did.
Right.
That is the problem. There is a case called Twombly and Iqbal. You may have run into that in various different situations. It's become the motion to dismiss standard that you cite when you file a motion to dismiss, and it's actually an antitrust case. Twombly, Twombly, Twombly is an antitrust case. And what it essentially said is, if you file a lawsuit and you claim someone is price fixing, bid rigging, horizontal allocations, and all the things that you just mentioned, but you don't have evidence and opportunity, then those entities can file a motion to dismiss and they'll be able to avoid trial. However, in a situation like this, if those entities had been sharing the keys to the kingdom competitively sensitive information, it's very likely that plaintiff who has made that allegation that everyone was price fixing, for example, would be able to survive that motion to dismiss. And then we're into discovery, which is often millions of dollars, and the risk of a jury trial. So that is the concern that the parties have.
See,
And
one of the issues that I have, or the concerns that I have, is the applicants are asking me to make a decision in the abstract. I haven't seen any of this. I'm having to take it on faith that what you're telling me is the gospel. But I don't know. I haven't seen any of these documents. I haven't seen any of these information. And I appreciate and understand if you provide it to me, it is theoretically FOIable. Okay. So it's not that I'm undercutting the argument. I understand it. Okay. But to issue a ruling on something this substantive, at least for me to be comfortable, I'd have to view it. And I'm concerned that if you really are correct about potential antitrust violations, providing it to me to review would be problematic. You appreciate my conundrum here?
I do. Let me also mention one thing before I come to that. There's a piece you were focused on. What is it that the companies might do as collaborative illegal conduct with each other?
Yeah. Is it vertical price? It's not. I guess it might be monopolization. I don't know. Although, as I understand it, they already have locked up everything in this formation already for the most part. So they've got a monopoly on the brine production.
That's issue number one. Issue number two is what this information would show and allow the suppliers and other third parties, not not the brine companies themselves, to do that would also be problematic under the antitrust laws. And here we're talking about, as you can imagine, there are dozens and dozens of key sellers of inputs, whether that is steel pipe, well services, bromine production services. I'm sorry, in this case, lithium production services, people who build the facilities, the actual plants in which these processes are done. All of that information would potentially be exposed, and that would cause those folks to have a roadmap to more easily rig their bids to the brine companies or otherwise disrupt what is normally a confidential competition in between them. And in my discussions with the producers, that's actually the much larger thing that they are concerned about. They can control their ability not to go commit bid rigging, and hopefully they would win a lawsuit if they were sued under the assumption that they were fixing prices. But what they can't control at all, because it's third parties, is the damage that releasing all of their cost and strategy information would do to them, and potentially cause a cascade of making it easier for price fixing, market allocations, disruption of competition, pulling your competitive punches, all those other phrases among the people who do services for them. And that ultimately is likely to raise prices for them and be passed on to the consumer. So that is, you focused on what is it bad that the production companies may do with this. We are also at least equally focused, probably more focused on the bad that may happen from these third-party companies that provide services and inputs to us.
I understand. I appreciate your presentation. Thank you very, very much. Mr. Perkins? And we're just, I gather, on antitrust, not confidential. We haven't even gravitated into that yet, which is another whole can of worms.
So first, I don't know if there may be a misunderstanding about what the subpoenas request. They don't request, this wasn't a document request. This was a request to require the companies to have a person available at the hearing that is knowledgeable in those areas. Now, our antitrust lawyer said that, you know, this, in order to be actively supervised, it would need to be a decision of the commission. He said the commission could do that, but that's the commission decision to make. And that's exactly what will happen at the hearing. Those witnesses will show up, presumably, or maybe not. But if they do, the commission, they can make all their arguments to the commission. Oh, you shouldn't make them answer that question, or that's anti-competitive, or whatever that might be. But the commission then would decide what it requires within its jurisdiction under the Brine Act, and its jurisdiction is very broad. And I'm questioning, I just don't understand. I'm not an antitrust lawyer, and kudos to Mr. Welford in DC. It's not an area that I ever practiced in, but this is something that I know. In December, Standard Lithium showed up and introduced their feasibility study. And in this application, I attached their feasibility study that they didn't introduce from SWA Lithium, which is one of the applicants here. Let me read you from their table of contents of this 200-page report what some of the sections include: a CapEx summary, sustaining capital, land costs, operating expenditure estimate, basis of estimate, direct operational expenditures, indirect operational expenditures, mineral rights, royalties, and land fees, OpEx summary, all-in operating costs, exclusions, upside production analysis, economic analysis, evaluation criteria, taxes and royalties and lease fees, depreciation, corporate taxes, property tax, federal funding and tax benefits, CapEx spend schedule, production revenues, cash flow projection, economic evaluation results, sensitivity analysis conclusions, upside production scenario, and deviation of alternative upside scenario from base case. And I'm sure that if Standard Lithium had been prosecuted for antitrust violations, we would have heard about that in his presentation, but we didn't. And so there seems to be something going on here.
I hesitate to interrupt the purpose. The Standard Lithium is subject to Canadian securities laws. We were talking about United States securities laws. They're two different things.
And they're also listed on the United States Stock Exchange.
You're arguing with one another. You need to be just arguing with me for the most part. But you can bring that up on your own there, Mr.
So maybe that's their answer. Only Canadian companies have to, are exempted from disclosing all of that information. And if that's the case, so be it. But it still doesn't change the fact that the commission can make the decision about whether they require this type of information. And certainly in the past, they have indicated that they do require it.
Well, all that information was provided, but apparently it still was slightly insufficient. Go ahead, Mr. Parkins.
And with regard to Mr. Daly's presentation about, you know, saying, oh, we can't possibly give you anything about the contents of our leases and so forth, but maybe he can explain how they can produce that information for Arkansas leases, but if they introduce it for Texas leases, that's an antitrust violation. I don't understand that. But in their application, they make the claim about all these things they couldn't possibly do. From their application, page 4, it says a direct sales net back cost-based compensation model would also require release of actual extraction, processing, and refining manufacturing costs, as well as customer sales contract data. The co-applicants intend to extract lithium ions using direct lithium extraction technologies and other confidential or trade secret processes to manufacture one or more unique marketable products, such as lithium carbonate, et cetera. So they're saying we couldn't possibly reveal the information that's required for a direct sales net back cost-based compensation model, when in fact, they themselves have executed leases that contain exactly those kinds of provisions. I have copies of them where it's based on the sales price less a whole long laundry list of deductions, which they will have to disclose if any of those royalty owners want to see detail on their royalty statement. So this statement in their application is just false. And they don't want us to be able to present the actual leases to the commission so that they can see that it's false. And that's really what's going on here. It's hide the ball. We don't want to tell the commission how much money we're going to make from this. We don't want them to know anything about what our leases say or how they would be constructed from a legal standpoint. The argument, earlier today, Mr. Daly said, oh, it's one big smackover formation and all has lithium in it. But his claim now is, well, if you step 1 foot across the Miller County line into Cass County, Texas, it's completely different. And he said, they don't have any Brine Act. True. They don't even know who owns it. Is it the surface owner? Is it the mineral owner? True. All of those things would mean that the prices they're getting in Texas should be less because there's so much more risk, according to Mr. Daly. But they desperately don't want you to know about all those 10% leases that they're signed in Cass County, Texas. And that's why they don't want it included.
Thank you, Mr. Parkins. Mr. Hickey? Mr. Pinkleton? Do we have some antitrust concerns here, sir?
Let me first say that I am not by any means an antitrust aficionado.
I am not either, but I tried to learn as much as I possibly could when the motions were filed. Probably enough to be dangerous.
I did as well, and I probably couldn't pass the test right now. But what I can say is that I looked at the procedure that we have for our subpoenas. as we have done this before, gone through this procedure. I believe the subpoenas were executed pursuant to our statutes and our rule. I believe you were delegated the ability to issue those subpoenas. I believe we have two statutes, one in the Bryan Act and one in our general statutes that allow those to be issued. They also have language in there that indicates that the complying with the subpoena and testifying doesn't subject you to penalties. I believe there's a reference in there to that may be applicable here. If I need to pull the statute, I can, but
No, I've got the statute.
okay.
Would you agree with me if I look at it, in terms of the subpoena powers, at least at the administrative level, I don't have the ability to hold the co-applicants in contempt for not adhering to the four corners of these subpoenas. Now that it's the commission, they can't hold them in contempt or penalize them from a, contempt perspective, I guess. But if the commission was sincere about ensuring adherence to these subpoenas, they would have to go to circuit court to get them enforced.
That is my understanding of the procedure that would have to be followed to compel compliance with the subpoena. Yes.
And at the circuit court level, all the protections that the commission does not have to shield some of this information from each one of the co-applicants, to ensure that confidentiality isn't broached, to ensure that antitrust laws aren't available, exists at the court level.
Yes.
All right, anything else you want to add, Mr. Pinkleton?
Add that I believe the procedure's been followed. I understand the concerns about having the full commission weigh in on this issue. I think that was addressed in the briefs. We defer to the commission on that.
All right, before you sit down,
Sure.
does the staff have any recommendation or position on Mr. Daly's motion to quash these subpoenas?
There's been the aspect of state immunity that has been brought up. I think the statutes indicate that compliance with the subpoena does not subject the testifying entity to the penalties. We believe that would include any of the penalties associated with what was referenced in the motions. The aspect of whether or not there is enough supervision is something that we agree that the commission does need to address this wholeheartedly. We are always in favor of addressing something that big with the entire commission. So we believe that the subpoenas were properly issued and need to be complied with.
All right, thank you, Mr. Pinkleton. Mr. Daly?
Hey, Judge Moulton, just a couple of points. So I get this thing back. Co-applicants do not object to the release of public information. The studies that Mr. Perkins referred to earlier are in the public domain. And we're not trying to conceal anything that's in the public domain. As Mr. Honey tried to point out, the rules that apply to Standard Lithium and the Canadian Stock Exchange, or whatever you call it, requires the publication of a lot of information that is never published in the United States. And Mr. Perkins can make what he wants to attempt to make out of that public information. Moreover, there are certain costs that the co-applicants are going to have to reveal regardless. And Mr. Perkins pointed that out in his briefs, but he didn't point it out entirely accurately. The commission, when an application for a unit is formed, requires that the applicant project its costs for the unit. But that's what the unit is. The unit is the wells and perhaps the pipes that connect the wells to one another. And the reason for that is that when you form a unit, if you have uncommitted owners therein, they're entitled to make a decision whether or not they want to participate with their interests. And if they have to make that decision, they're entitled to information so that they can intelligently, somewhat intelligently, make that decision. But what do they get to participate in? They get to participate in the unit. These are the wells that go down in the ground, bring the brine out of the ground, and then subsequently re-inject the brine after it's been produced. If we look at the statute, which requires this revealing of information, the order requiring the operation of an area of brine production or brine expansion unit shall include several things, including 4, a statement of the tangible and intangible expenses of the development and operation of the unit, including capital investments required in the development and operation of the brine production unit or brine expansion unit. Here's what's not been mentioned: exclusive of the plant of the producer. The statute does not require, for very good reasons, information about what happens cost-wise and process-wise after that brine gets to the surface and before it goes back into the ground. Because all the participant gets to pay for and all the participant gets to receive is the right to get the brine out of the ground from the wells and the duty to put it back when he's done. And what we're talking about is not those costs. Certainly, we'll project those costs. They've been projected in connection with the formation of the units that have been formed. What we're talking about and what he wants is how are you going to make this lithium after you've got the brine, and how are you going to make it into lithium carbonate or lithium hydroxide or lithium oxide, and how much is that going to cost, and how much are you going to sell it for? That's the plant. That's that area that's off limits under the statute.
And that's because sharing that with your co-applicants would result in potential problems.
It is because sharing it with the co-applicants would prevent, would
And if the
trigger an antitrust problem and would allow, as you've just heard, would allow prospective vendors and purchasers to basically gang up and as to vendors get to the highest common denominator and as to purchasers to get to the lowest common denominator. That's why it's exempted under the statute. Yet he's demanded it and convinced you for at least a moment to issue a subpoena to it for us.
So, Mr. Daly, don't provide it.
Well, I think
What would be the problem?
I think that's exactly going to happen.
Okay.
But then we have to decide whether or not we're going to be forced with some sort of an enforcement procedure.
I mean, the only enforcement would be if the commission decides that they want to, that they want, and then you have the umbrella of protection from a circuit court in the state of Arkansas as opposed to an agency.
I can tell you that non-public information of this nature is not going to be provided, subpoena or not.
I understand, and I appreciate that. Nobody wants to jeopardize lithium from being produced in this state. I don't want to have it jeopardized.
So I think we're in a process of doing that, and I'm very concerned about it.
Well, I would hate for that to be the case, because certainly in the previous one, it didn't seem to be an impediment, but in any event, all set?
The
Thank you,
statute
sir.
says the plant's off limits.
Thank you, sir. Mr. Perk, I'm sorry. I'm having a brain. I'm sorry, sir. What's your name again? I apologize. Up,
Well,
Mr. Walford. I'm sorry.
Just,
Walford.
Your Honor, this is Hill Welford, yes.
Yeah. Anything else you want to add, sir?
No, sir, I think you understand it. It sounds like there may be a path forward here where we the producers can provide what we think does not get us in trouble. And then we can have a further discussion that may be productive with both the commission and Mr. Perkins. And I think that would be a good result.
I think so too. I mean, my concern, sir, is that we went through one of these proceedings previously, and the commission just wasn't satisfied with what was provided. And so I don't want us to get all together and then not have anything provided, because I don't think we will have enough information for the commission to make a decision what a fair and equitable lithium royalty is going to be. Again, I can't decide because it's all in the abstract. I haven't seen anything except the application, and the application is very thin in terms of what's going to be provided at this hearing. I don't have a crystal ball, and I don't have a crystal ball in terms of what Mr. Daly and Mr. Honey and the rest of the co-applicants intend to introduce to support their application. And I don't have a crystal ball because I don't know what the commission wants. But I certainly don't want to jeopardize or harm any of the co-applicants, their confidential secrets. We don't want to gravitate into any antitrust violations. I'm cognizant of the co-applicants' concerns in that regard. And so, well, I guess I'll just move on. I'm beating a dead horse at this point. Do we need to get into the confidential aspects, Mr. Daly? Because your motion to quash had two prongs. Do you want to get into the confidential? Because I'm fully aware and I understand those concerns too. I think they have too.
the reason for both antitrust and the need for confidentiality as a business matter merge. They're the same.
But I mean, you would agree with me, but at the administrative level, I don't have the ability to enforce you to comply with this subpoena. I understand the specter that exists with it still hanging out there. But by the same token, I also think that if the commission thinks that they want this information that's contained in this subpoena, they can do what they need to do in order to go to court to get it complied with. And then again, you have all the protections that you need to make certain that this information isn't shared among your co-applicants.
I still want to make a point about Texas.
Sure. Oh, I understand the concern about Texas. Yes.
Texas is a different jurisdiction. Texas has different laws. The commission has never, ever, ever required information outside of the very unit where a well is. And he wants to beat a bunch of Texas leases over our heads because he can't find any in Arkansas to speak of that were taken by anybody that has anything to do with this application. And that is not relevant. And the statute specifically says, as is the Administrative Procedures Act and the commission's own rules, that the hearing officer can exclude irrelevant evidence.
Well, again, I'm sorry, Mr. Taylor, my apologies. Mr. Perkins, anything else you want to add to that? Sorry.
I could, but I'm not.
Oh, come on. You get the time. Go ahead, sir. All right. Mr. Hickey? Mr. Pinkleton? Anything? All right, thank you very much. Why don't we do this? Why don't we take a 15-minute break? I will try to give you, to the best of my ability, some preliminary indications on the way I may rule. However, I'm also going to memorialize everything in some sort of memo to either the commission or the chair, but I will at least give you an indication of the way I'm leaning, with the caveat that after I look at everything again, I may change my mind. So if you're comfortable with that, if you want some sort of preliminary indication on things, give me 15 minutes and I will try to do it. And if you want to wait until the written decision comes out, what's the prerogative of council? What would you like me to do? Mr. Daly, Mr. Honey?
I think, if you feel comfortable providing us with just a preliminary indication, I think that would be helpful.
I'm gonna give it a whirl. Mr. Perkins? Thumbs up for Mr. Perkins. Mr. Pinkleton? Mr. Hickey? All right. We'll go off the record for 15 or 20 minutes. Come back on and I will do my best. I don't mean to cut off your conversation, sir. I never meant to cut your conversation off at any time. All right. We're back on the record. First off, let me thank everyone for their presentations this morning and a little bit into this afternoon. You have helped crystallize some issues and in some instances made me rethink a couple of matters. So from the perspective of the arguments on the pre-hearing, I believe you've helped me out quite a bit. So these are going to be my recommendations. I am going to recommend that in terms of the motion for declaratory judgment as it relates to the Hickey objector letters, I'm going to recommend to grant the co-applicant's motion as it relates to the issues that the AOGC is empowered by statute to determine royalty for additional extracted substances, that the Brine Conservation Act and the Arkansas Oil and Gas Commission's administrative hearing process is constitutional, and that the brine leases and integration orders covering the brine interests owned by the Hickey objectors include all chemical substances extracted from brine, including lithium. Again, I will memorialize those in order. Hopefully I will have that order completed. My finish date is October 15th. My self-imposed deadline is October 15th, 2024. In regards to the motion for declaratory order as it relates to the co-applicant's motion regarding the SAMA objection, I'm leaning and recommending that the co-applicant's application does not violate the Arkansas Administrative Procedures Act, that it is indeed a quasi-judicial proceeding and not rulemaking. I am going to recommend that the co-applicants, as it relates to the royalty rate on additional substances, be determined on a unit-by-unit basis. I'm going to grant that in part in terms of, I think the co-applicants need to amend their application to include the existing brine units that are contained in the formation. If you want to have the formation in there, I want the commission to have the option in that application to either set a royalty on the existing brine units or potentially put it in the entire formation. My concern is if you just leave it on the formation, that is going to be considered an act that is outside the statutory authority of the Brine Act. So I'm going to recommend that you, again, amend your application, include the existing brine units that are in the formation, so you're providing the commission with an option to just set a royalty on the existing brine units or expand it to the formation. I'm not going to issue a decision on Albemarle's standing to participate in the docket because I want to get an opportunity to review the dockets that Mr. Pinkerton brought up on standing in a proceeding, and I haven't had a chance to do that. I don't want to pull the trigger on that issue. I'm going to wait. I'm also going to wait. I want to take another look on the argument in the declaration that the Brine Act does not require the AOGC to wait until an additional substance is extracted before determining a fair and equitable royalty on the additional substances. Although I will freely admit, it certainly seems to me at first blush that's what the statute requires. And it certainly is consistent with the previous application that was provided. I'm leaning in that direction, but I need to review it one more time before I finalize that decision. And in terms of the subpoena, I am not going to grant the motion to quash. I think the subpoena was properly issued. And I think the applicants or the co-applicants have the ability not to comply with it at the administrative level. If they don't want to, if they think that something that subpoena is requesting is going to be an antitrust violation or going to violate confidentiality, I think you are free not to provide that. But I don't know what the commission wants. And I also don't know, because this information hasn't been provided, justifiably so, because this is an administrative agency, and I don't have the ability to shield that. I don't want to get into an antitrust violation. I don't want to get into breaching any confidential aspects. I also think that what the subpoena is asking for seems consistent with what the commission wanted previously. They were looking for information, substantive information, financial information, things of those nature, and they just didn't have enough. If the commission thinks that those subpoenas need to be enforced, then it'll be up to them and their prerogative to go to circuit court and try to get an order. And again, then you are provided with a suite of protections that a circuit court can provide you in order to shield some of that information from violating a confidentiality or an antitrust, something that I can't provide. But again, I don't have a crystal ball. I don't know what the commission wants in terms of the information. I say that with the caveat, I'm going to look at the Texas royalty leases one more time. The denial is not extended to those Texas releases, because it may be that you have a point, Mr. Daly, that they are just not relevant to this proceeding. That's going to be my preliminary. Like I said, take it with a grain of salt. I may dig into this as I go through this again, read it, and possibly change my mind on some of these things. But after what I've heard before today, and the fact that we have such a short window before the November 4th and 5th hearing, I wanted to give council sort of a heads up on what I think the final order is going to be. Any questions? If not, thank you all very much for your time. Thank you all again very much for your presentations. We are off the record.